Senate will come to order. Mr. Schaffler, please call the roll.
Senators Amabile, Baisley, Ball, Bridges, Bright, Carson, Catlin, Cutter,
Excused.
Danielson, Doherty, Exum,
Excused.
Frizzell, Gonzalez,
Excused.
Henriksen, Judah, Kip, Kirkmeyer, Kolker, Liston, Lundin, Marchman,
Excused.
Michelson Janae, Mullica, Pelton B, Pelton R, Rich, Roberts, Rodriguez, Simpson, Snyder, Sullivan, Wallace, Weissman, Winter,
Excused.
Mr. President.
Let's do this for 2 more days. 30 present, 0 absent, 5 excused. We have a quorum. Senator Simpson, would you please lead us in the Pledge of Allegiance?
Thank you, Mr. President. Colleagues, friends, and guests in the chamber, please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Schaffler, please add Senator Winter to the roll, and Senator Cutter to the roll, and Senator Marchman to the roll, and he's probably taking his jacket off and getting comfortable. We'll keep it moving. Approval of the journal, Senator Mullica.
Thank you, Mr. President. I move that the Senate Journal of May 5th, 2025 be approved as corrected by the Secretary.
You've heard the motion. All those in favor say aye. Opposed, no. Ayes have it. That motion is adopted. Senate Services.
Correctly printed, Senate Joint Resolution 23 and 24, correctly engrossed, Senate Bill 322, Senate Resolution 12, correctly re-engrossed, Senate Bill 321, correctly revised, House Bill 1192, 1267, 1292, 1312, 1322, and 1329, correctly re-revised, House Bill 1021, 1121, 1157, 1159, 1186, 1188, 1189, 1223, 1278, 1288, and 1335, correctly enrolled, Senate Bill 61, 142, 158, 273, 278, 285, 292, 295, 308, and 311, Senate Resolution 12.
Committee reports.
Committee on Finance. After consideration on the merits, the committee recommends the following. House Bill 1302 be postponed indefinitely.
Mr. Schaffler, please add Senator Exum to the roll. Proceeding out of order for moments of personal privilege, Majority Leader Rodriguez, it is not me this time, I promise.
Thank you, Mr. President. I move that the Senate proceed out of order for a moment of personal privilege.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. That motion is adopted. We proceed out of order for a moment of personal privilege. Senator Catlin.
Thank you, Mr. President. I ask for a moment of personal privilege.
Granted.
Thank you, sir. Members, this morning I wanted to come down here and commemorate a person that had a great influence on my life. You don't need to stand, but thank you. What I wanted to talk to you about is the guy that raised me. Today would have been his 94th birthday. I hadn't had an opportunity in my career here in the Capitol building in order to put Keith Catlin's name in the record for the state of Colorado. He passed away in December last year, and I hadn't had an opportunity to talk about him. So I thought today I would take the opportunity and thank you to the Majority Leader for allowing me a moment of personal privilege. In reality, I lost him probably a year or more before that because the man lost his mind to dementia. A man that had been in direct control of everything in his life. It was one of those guys that that generation just couldn't pass the reins off to someone else because the reins had grown into his hand. And he continued to make decisions right up until he couldn't. So one of the things that I'd like to ask of each and every one of you is if your parents are showing some of the signs, get them looked at. Have somebody help you with that. Because that was what made this so much harder than what it probably could have been. But the point is, I have a lot of respect for the man. I loved him like you know that I would, but we had been very good friends too, which is one of the marks, I think, of good parenting in this day and age, is that the people that you've raised end up wanting to be your friend after they're full grown. You've probably done a pretty good job. But one of the things I wanted to commend him on is that my mother had taken really sick, and he devoted his life to her for 5 years. She couldn't eat, so she had a feeding tube. He took care of that feeding tube every day. That was his whole job. When she passed, he didn't have focus. And I think that may have been what happened to him. But the point was that I asked him once, can we get you some help? He turned and looked at me and said, no, you can't, because I gave my word that I would take care of her. And he did. So anyway, I wanted to commend him, and I wanted to let the world know that he was a good one. Thank you very much.
Thank you, Senator Catlin. Mr. Schaffler, please add Senator Gonzalez to the roll. Further moments of personal privilege. Seeing none. Majority Leader Rodriguez.
Thank you, Mr. President. I move to proceed out of order to take up third reading of bills consent calendar.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The Senate will proceed out of order for consideration of third reading of the bill's consent calendar. Third reading of the bill's consent calendar. Majority Leader Rodriguez.
Thank you, Mr. President. There has been a request to remove Senate Bill 322 off of the third reading of bills consent calendar and will be placed on third reading of bills.
Third reading of bills, Senate Bill 322 will be removed from third reading of the bill's consent calendar and will be placed at the end of the third reading of the bill's calendar. Third reading of the bill's consent calendar. Mr. Schaffler, please read the title of the bill on the consent calendar.
House Bill 1329 by Representatives Mabry and Soper and Senators Frizzell and Gonzalez concerning foreign third-party litigation financing for civil actions.
Majority Leader Rodriguez.
Thank you, Mr. President. I move the Senate pass the bill on third reading of bills consent calendar, which is House Bill 1329.
Any discussion on the bill? Seeing none, the motion is the passage of the bill on the third reading of the bill's consent calendar. Are there any no votes? Senator Baisley.
Thank you, Mr. President. I want to seize my one opportunity to be counted as a no vote on House Bill 1329, please.
Senator Baisley will be counted as a no vote on House Bill 1329. Senator Roberts.
Thank you, Mr. President. I ask to be recorded as a no vote on House Bill 1329.
Senator Roberts will be recorded as a no vote on House Bill 1329. Senator Ball.
Thank you, Mr. President. I ask to be recorded as a no vote on House Bill 1329.
Senator Ball will be recorded as a no vote on House Bill 1329. Further no votes? Seeing none, with a vote of 32 ayes, 3 noes, 0 absent, 0 excused, House Bill 1329 is passed. Co-sponsors. Majority Leader Rodriguez.
Thank you, Mr. President. I move the Senate proceed out of order for third reading of bill's final passage.
You've heard the motion. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. The Senate will proceed out of order for consideration of third reading of the bills calendar. Third reading of the bills. Final passage. Majority Leader Rodriguez.
Thank you, Mr. President. I move the Senate proceed out of order to take up Senate Bill 322.
You've heard the motion. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. The Senate will proceed out of order for consideration of Senate Bill 322 on third reading and final passage. Mr. Schauffele, please read the title of Senate Bill 322.
Senate Bill 322 by Senators Bridges and Baisley and Representative Byrd concerning the management of consumer protection claims by the Attorney General.
Senator Bridges.
Thank you, Mr. President. I request permission to offer a third reading amendment on Senate Bill 322.
Senator Bridges, please tell us why you want permission for a third reading amendment.
There is a member of the House that is holding up another bill and will not allow that bill to pass unless the title on this one is narrowed. So this amendment narrows that title.
Yo, that's crazy to say that on the mic. The request is Senator Bridges' request for permission for a third reading amendment. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and permission is granted. There's a member of the desk, Mr. Schauffele, please read L004 to Senate Bill 322.
Amendment L004, amending
Senator
gross bill.
Bridges.
Thank you, Mr. President. I move L004.
To the amendment.
This changes the title, narrows it to following general in relation to discovery requests during the litigation of claims brought by the Attorney General. Narrows the title, which is not really effective in any meaningful way, but it does narrow the title. Ask for an aye vote so that things can get moving over in the House.
Further discussion on L004. Seeing none, the motion is the adoption of L004 to Senate Bill 322. Are there any no votes? Senator Roberts. With a vote, there is a no vote as well for L004, Senator Kirkmeyer. Further no votes on L004. No votes on your own. Senator Bridges is a no vote on his amendment, which is excellent. The minority leader is a no vote. Senator Pelton B is a no vote.
Oh, wow.
Senator Amabile. Mullica. What is going on? Bright. Simpson. Rich. Frizzell. Carson. Catlin. Marchman. Pelton R. Liston. With a vote of 19 ayes, 16 no, 0 absent, and 0 excused, L004 is adopted. Senator Bridges, just to make sure, please move Senate Bill 322. Senator Bridges.
Thank you, Mr. President. I move Senate Bill 322.
And Senator Bridges.
Thank you, Mr. President. This bill actually is very important for the Attorney General in discovery cases so that when there is reverse discovery, it's not every single department of the state that is open to reverse discovery. Of course, as third parties, they would be open to discovery if they have relevant records, but the opening up all of their records for all of state government just because the Attorney General is involved in a lawsuit doesn't make any sense. Ask for an aye vote on this important piece of legislation.
Further discussion on 322. Seeing none, the motion is the passage of 322 on third reading and final passage. Are there any no votes? With a vote of 35 ayes, 0 noes, 0 absent, 0 excused, Senate Bill 322 is passed. Co-sponsors.
Yeah.
Majority Leader Rodriguez.
I withdraw that. Withdrawn.
You withdraw your hand.
I forgot what we just did.
Do you want to move the balance of the third reading calendar layover, Mr. Majority Leader?
Is that what you were asking me for?
Yes, sir. Mr.
Thank you,
Majority Leader.
Thank you, Mr. President. I move to lay over the balance of the third reading of bill's final passage till later in the day.
There we go. The motion is laid over the balance of the third reading of the bill's counted later in the day. All those in favor say aye. Aye. Opposed, no. The ayes have it. The balanced third reading bills calendar will lay over until later in the day. Majority Rodriguez.
Thank you, Mr. President. I ask for Senatorial 5.
Senatorial 5 has been requested and granted. Back in the game, Majority Leader Rodriguez.
Thank you, Mr. President. I move that Senate proceed out of order for announcements.
The motion to proceed out of order for announcements. All in favor say aye. Aye. Opposed, no. The ayes have it. Proceed out of order for announcements. Announcements. Senator Roberts.
Thank you, Mr. President. Colleagues, an announcement that the Conference Committee for Senate Bill 37 will meet at 11 a.m. or as soon as possible thereafter in Committee Room 354.
Very good. Further announcements. Senadora Gonzalez.
Good morning, Mr. President, colleagues. The Conference Committee for Senate Bill 155 is scheduled for 11 a.m. today, May 6th, in Senate Committee Room 352.
Very good. Further announcements.
Any other conference committees?
Conference committee report.
Your first conference committee appointed on House Bill 1209 concerning measures to address efficiency in the regulation of marijuana licensees and in connection therewith, reducing an appropriation has met and reports that it has agreed upon the following. One, that the House accede to the Senate amendments made to the bill as the amendments appear in the re-revised bill. Two, that under the authority granted the committee to consider matters not at issue between the two houses, the following amendments be recommended. Respectfully submitted, House Committee Representatives Lindsted, Chair, Wilford and Gonzalez. Senate Committee Senators Gonzalez, Chair, Rodriguez, and Simpson.
Senator Gonzalez.
Mr. President, I've just been informed that I was mistaken. We will be meeting in the Senate Committee Room 357 for the Conference Committee on Senate Bill 155.
Very good. Special orders. Second reading of bills. Senator Bridges.
Thank you, Mr. President. I move the Senate resolve itself to the Committee of the Whole for the consideration of special orders, second reading of bills.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The motion is adopted. The Senate resolve itself to Committee of the Whole for consideration of special orders, second reading of bills. Counter and Senator Bridges will take the chair.
The Senate will come to order, and the coat rule is relaxed for everybody. Even if I don't have the power to relax it, consider it relaxed. Will the clerk please read the title to one of the Senate bills? House Bill 1291. Oh, Senatorial 5. Will the clerk please read the title to House Bill 25-1291?
House Bill 1291 by Representatives Wilford and Froelich and Senators Winter and Danielson concerning measures to increase protections for persons engaged with transportation network companies.
Senatorial 5. Senator Winter.
Thank you, Mr. Chair. I move House Bill 1291 and the associated Business, Labor, and Technology Committee report.
To the committee report.
Okay.
Senator Danielson.
Thank you, Mr. Chair. In the Business, Labor, and Technology Committee, we ran several amendments, and we urge an aye vote on the committee.
Is there any further discussion? Seeing none, the motion before us is the option of the committee report. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. The committee report is adopted. To the bill, Senator Winter.
Thank you, Mr. Chair. Members, this bill is not just about one person, and it came from one person. But this is about everyone that has been harmed, assaulted, and sexually assaulted in an Uber or Lyft. And I want to share the words of the good representative from North Glen on her experience and why this bill is so incredibly essential. When I was a kid, my family had safety rules. These were especially important because starting in middle school, I walked to and from school. Don't talk to strangers. If someone offers you a ride and you don't know them, say no. If someone offers you a ride and you do know them, but they say our password, say no. And they don't say our password, say no. If someone tries to take you, fight. Do what you need to do to get to safety. These are the rules I've taught my children and rules I've lived by most of my life. And last February, I followed them. I met up with friends in Cherry Creek for drinks. I ordered a lift down. I have a personal rule to not drink and drive because my uncle was killed by a drunk driver 10 years ago. When I was ready to go home, I ordered a ride. I thought I was being responsible, making the right choice. What I didn't know was that I would be paired with a driver who is letting a friend use their profile. Unfortunately, account sharing or account renting is far more common than rideshare companies like Uber and Lyft are willing to admit. And in my case, either Lyft ignored the account sharing, which is against the rules, or they just didn't care because they did nothing to prevent it from happening. A few minutes into the ride, the driver started asking me personal questions, like if I was married, and then quickly escalated to inappropriate comments about what he wanted to do to me and how he felt that my husband wouldn't mind if we had sex. He had a plan for how he wanted his night to turn out, and I was trapped in his car. I texted my husband and neighbor during the ride because I was scared of the confidence in the driver's words. I've taken run, hide, fight training, so as we got closer to my house, I took off my heels so that I could run away faster. As he pulled up just past my house, I thought the nightmare was almost over, but it wasn't. It was just beginning. He put the car in park and quickly got to the back seat. He kept moving my face, trying to kiss me. When I tried to get out of the car, he blocked my exit and pushed me back down into the car and went on to sexually assault me. I've gone to a lot of therapy now. Understand that what happened to me in those moments that felt like an eternity with disassociation. My body was there in that moment, but the person that stands before you today, that person wasn't there. I had to physically push my way out, and once I got out, I didn't stop. I ran down my neighbor's driveway and hid in their backyard until I was safe to go home. I have no doubt in my mind that he's done this before. He felt entitled to take what he wanted, and it didn't matter how many times I said, I'm not interested. It didn't matter how many times I said no. After I reported the sexual assault to Lyft, they promised to never match me up with that driver again and gave me a refund. To this day, I don't know if that profile used to assault me is still active, if they're still matching him with others, if they have an active profile on Uber, or if the person who assaulted me has their own profile on either platform, because they don't tell survivors the outcome of an investigation. I was raped in college. I didn't report. I locked it away for over 20 years, telling no one, and it took its toll. I kept thinking I've already been through this. It can't be happening again. This can't be the world I'm raising my daughter in. I never expected to be a 37-year-old mom of 2 going through something so horrific. So I made a decision to file a police report. When the detective assigned to my case sent a search warrant to Lyft in order to get information about the driver, I asked how long it might take to get information back and was told it could take anywhere from a week to over a month. And in the detective's experience, Uber and Lyft do not respond quickly or with urgency to similar requests. Since that night, I've lived with the weight of trauma that refuses to stay quiet. I've gone to therapy, desperate to not be the mom who cries all the time. Desperate to be able to do things that once felt easy again. Desperate not to freeze when I see someone who looks like him. Desperate not to be haunted by his eyes in the rearview mirror. Desperate to feel safe in a world that doesn't feel safe anymore. Even when you follow the rules, nobody should be made to feel that way. According to Uber's own community safety numbers, members feel free to be seated. That's the end of the story, and now I'll share some data. Thank you. According to Uber's own community safety numbers, there have been 8,698 sex assaults from 2017 to 2022. According to Lyft's own numbers, there have been 6,809 sex assaults from 2017 to 2022. We know that on average, only 30% of sex assaults are generally reported. The figure for actual assaults during this period may have been closer to 51,000. In working on this bill, I've learned that Lyft categorizes sexual assaults into 21 categories and only leads with what they consider to be the top 5 most egregious. Uber does the same thing, but they call it a sexual assault taxonomy. Can you imagine reviewing what was likely one of your worst days in a person's life and deciding which category their experience should live in on a spreadsheet? Lyft and Uber hide behind their taxonomies categories so they can minimize their problem. Let's be clear. One sexual assault is too many. The numbers of assaults on drivers are also staggering. According to Pew Research, 19% of gig workers have experienced unwanted sexual advances while working. According to the Drivers United, 1 in 4 drivers who experience sexual harassment also reported experienced sexual harassment while driving. In 2022 alone, 31 app workers were killed by fatal assault by driving, 27% of them by a passenger. Uber and Lyft have a severe safety issue and are in crisis. I will say that again. Uber and Lyft have a severe safety issues and are in crisis. Whether they want to admit it or not, it's why they've spent billions on marketing to convince the public they're safe. They stay on message, safety, safety, safety. Whenever something terrible happens on their watch, they double down on their safety talking points. The formula is always the same. This is terrible, we take it seriously, safety, safety, safety. I want to take a moment and read a few of the statements from Uber and Lyft that we've seen over responses to sexual assaults. The behavior described in this incident has no place in our society. We take reports of sexual assault very seriously. And when incidents such as these are reported to us, our trained team takes immediate action to investigate and works with local law enforcement so that appropriate actions can be taken. As a platform committed to providing safe transportation, we hold ourselves to a higher standard. Transportation network companies like Uber and Lyft exercise full control over their platforms and have continually opted to implement the lowest cost safety measures, which are inadequate. Let me say that very plainly. Uber and Lyft consistently prioritize their bottom line over the safety of riders and drivers. They profit off of people, taking them at their word that they are safe. In February 2016, Uber agreed to pay $28.5 million to 25 million riders to settle a class action lawsuit surrounding their advertisements. After the settlement, Uber was no longer allowed to use the term industry-leading or best-in-class in reference to their background checks. You only need to do a simple Google search for Uber Sexual Assault, Lyft Sexual Assault to find horrific stories that go back for years. In 2019, 14 women sued Lyft over mishandling their sexual assault, sexual misconduct, and rape complaints against drivers that occurred on their watch. In their lawsuit, the women outlined how Lyft chose to stonewall law enforcement investigation assaults and that it fails to inform victims about the status of the drivers they've accused of sexual assault. Last month, the U.S. Ninth Circuit Court of Appeals ruled that more than 1,600 sexual assault cases against Uber will be allowed to continue before a single San Francisco judge. Hundreds of rape survivors claim Uber skimped on driver background checks, failed to report sexual violence to police, and allowed sex offenders to drive for the company, all while banking millions in rider safety fees. Not everything's perfect. Those were the exact words Lyft's representative said to me, and I held our first stakeholder meeting and questioned Lyft's so-called gold standard of background checks. And they said, not everything's perfect. That's the kind of indifference survivors are met with every single day. Shrugged shoulders, empty apologies, a refund, and a promise to never match you with that driver again. A boilerplate statement. For years, survivors have been telling their stories and demanding accountability, but those demands continue to fall on deaf ears. They have been able to spend billions on campaigns to boost their image and talk about safety, 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 and drown out the experiences of survivors for too long. What they didn't expect, a state representative being sexually assaulted and refusing to be quiet. And I should not have had to be sexually assaulted for Uber and Lyft to pay attention. A state representative shouldn't have to elevate this issue for them to care. We heard from survivors who shared in March of 2022, I was a victim of a horrific assault in the hands of a rideshare driver. I was kidnapped, violently raped, strangled by a predator who hid behind the rideshare brand. This was one of numerous awful stakeholder stories we heard. Using the platform as a tool to target victims, in my case, justice was served. My attacker received 290 years to life in prison, but that sentence came at a devastating cost. 13 brave victims had to testify, and there were more. Sexual assault isn't something you get over, it's something you carry, and what I carry is a constant reminder that these companies knew better and did nothing. This bill isn't a punishment, it's a reckoning, it's a line in the sand. Survivors deserve safety, they deserve justice, they deserve change. The justice, change, and safety come with passing this bill. Would you, earlier last week, you got a toy car and a pair of dice on your desk, because that's what getting into an Uber or Lyft feels like right now. Every time it's a gamble. Would you roll the dice for your daughter or your partner or your best friend? I hope not. I did everything right, I followed the rules, and I was still assaulted. No more gambling with people's lives. Please vote yes.
Senator Danielson.
Thank you, Mr. Chair. Thank you to my colleague for reading the words of Representative Wilford. The thing that she wants to stress, at least my takeaway, is that it is not about one person. This policy is not about one person. But in her statement, you heard that it's because of one brave person who happens to be an elected official that we will see regulations on these companies that will prevent what happened to Representative Wilford from happening to someone else. This measure passed out of the House of Representatives 59-6. The survivors who have come forward to pour out their support for this measure are innumerable. They are passionate for this change. I have to admit, even though I work on sexual assault issues, child sexual abuse, and prevention, that this was an issue that I was not aware of prior to Representative Wilford coming forward with her story, which I don't like admitting, but I'm so very grateful for her bravery. because it opened my eyes to the broader community who have been sexually assaulted, raped, attacked violently by riders and drivers. So we have an opportunity here to act, to hold the companies accountable for the part in that they play, to require of them the safety mechanisms that they have the ability and the capacity to put in place. I ask you today to stand with those survivors. Since I started working on this bill, and the reason that I started working on this bill is because when I heard the press conference, I reached out to my friend because I didn't know what happened to her, and I just wanted to make sure she was all right. What can I do? I'm terribly sorry what happened to you. How can I support you? It's what one does, right? And she turned around basically the next day and said, carry my bill. That's what I want you to do. I want to do something about this. So I said, my goodness, thank you. Yes, I can do that with you. Yes, let's work together. But I'll tell you, I mean, I've been in 2 ride shares since I was made aware of these issues. And that's because my family went down to 1 vehicle for the 4 of us, which is difficult when you have a 7-year-old, a husband who works, and a 3-year-old that all need transported places, and when we have crazy hours. Taking the ride share was unavoidable for me, but I'll tell you, I'm not going to do it again unless I absolutely have to. What Representative Wilford included in her testimony is not unique. The difficulty in having any accountability or recourse from the company is nearly impossible. And that's not a theory. That's a testimony of men and women who drive for the company. We met a driver who was violently stabbed and almost died and tried to recoup some of the costs of the hundreds of thousands of dollars in hospital fees for just the first couple of days. I don't know if you guys have spent any time in a hospital recently, but that tracks. Of course, forced into a situation where they can't discuss it in public, and then forced to take a pitiful, offensive offering from the multi-billion-dollar corporation that allowed for that attack to happen. Because like most people in Colorado, taking the little crumbs is something, because money is tough to come by. And again, maybe you are in a family where that's not the case and have the amount of wealth that it would take to pay those bills out of pocket. No, I'm not, and most people that I know are not. So this person has to take those crumbs and never speak of it again. This is a story that we heard from many drivers. Not one, many. If you have heard the pleas of the survivor community here, we urge you to stand with them. This is a great opportunity to put your money where your mouth is. The second piece that I wanted to recognize is the incredible amount of work that my colleagues have made with the opposition of the bill to address the reasonable concerns. And some of them we set out and said, according to Senator Wilford, don't want to give her a demotion, Representative Wilford, were a line in the sand she wasn't willing to cross on principle. And you know what? She did, and accepted a number of amendments that were off the table because there are still significant gains in protecting people from experiencing what she experienced. Significant gains. This is a strong policy. My colleague and I will run through a huge amount of compromise that the proponents and we have made here shortly. But still feel confident in the remaining policy that this is the policy with the integrity that we set out to keep, which is putting forward some meaningful regulation on companies who have the capacity to withstand it in order to provide some protections for riders and drivers against sexual assault and violent attacks. It's been my privilege to be a part of this because, again, when someone comes forward with a sexual assault, it is a devastating, life-altering event, and there typically is not a lot you can do except to respond the way the survivor wishes you to. You and I, we sit in a different position. We have the power to do something to protect people from this kind of attack. It's a unique thing. It's a really special thing. So I want to thank my sponsors for being willing to move way beyond what we thought we would be willing to do in order to preserve some of the protections that we worked really hard to put in place. And I believe that compromise should go both ways, but when we move through these amendments, it is going to be amendment after amendment after amendment after amendment of the sponsors giving to the opponents. And then some of the more reasonable requests from some of the drivers, for example, that were shared with other supporting organizations in the community. I mean, some of the concerns ran across the community and concerns that some of our colleagues here in this chamber expressed. We are so glad that we're able to accommodate that and keep that initial integrity that we set out to do. Thank you, Mr. Chair. I urge an aye vote on House Bill 1291.
Senator Winter.
Thank you. Please stand with survivors today. One sexual assault is too many, and these policies, we're asking for safety to be baked in and not an afterthought.
Mr. Minority Leader.
Thank you very much, Mr. Chair. Colleagues, what a horrifying experience. What a tragic failure of humanity. We can begin this conversation only with heartbreak and pain and anger at the evil one human being might perpetrate, did perpetrate upon another. There is nothing but solidarity in rejection of that sort of behavior and that sort of a circumstance. The challenge we now have before us is bound up in something that the lawyers, a phrase that the lawyers use, and if you've either been to law school or you've served on Judiciary Committee, you've undoubtedly heard this. Bad cases, hard cases, I got to get it right here. Hard cases make bad law. I would say that that is exactly the circumstance we have before us right now. Horrible circumstance, terrible fact pattern, terrible case. In fact, a case worthy of, and I believe, I understand, a pending legal action. Criminal legal action is absolutely the appropriate response under the existing laws. Then our response is, okay, now how do we craft policy, civil policy, that acknowledges the difficulty of the circumstances, the emotion of the circumstances, the visceral rejection we all have for that sort of a circumstance, and at the same time create policy that allows for an accepted service. One moment. When your phone rings in your hearing aids and your phone is on your desk, you have to grab the phone to shut the hearing aids off, or you can't think about what you're talking about. So it falls to us to craft policy to deal with this that provides the maximum safety that we want, because we clearly want to do things that enable the people of Colorado to live lives that they can expect are safe, that are generally safe. And at the same time, we must acknowledge you just can't make everything safe. So how do we craft policy that maximizes our opportunity to do that? At the same time, as in all policy conversations, there's a tug and pull. There is a requirement that we find the best way forward so that a service that is broadly used in society today, in Colorado today, can still exist and exist in a way that benefits the people, the customers that are receiving the service, the individuals who are providing the service, the companies that support that effort to bring the service. It's our burden to acknowledge the emotion, acknowledge the pain, to see it for what it is, and then step back and build policy that tries to find its pathway forward across all of these competing interests. A vote for safety, a vote for beneficial criminal and civil policy is what we seek. Mr. Chair, I appreciate your attention, your willingness to acknowledge or hear my acknowledgement of the very challenging path that sits before us and the narrow solutions that we may seek to find. Thank you, Mr. Chair.
Thank you. And members, the sponsors have a series of amendments they would like to put onto the bill. So we'll start with those amendments, and then we'll continue with broader discussion after that. Who wants to start? Senator Winter.
Thank you, Mr. Chair, and thank you to Mr. Minority Leader. And yes, we need to acknowledge the emotion and the pain that has happened, and we also need policies that work, and that's what we're going to do right now. And so we, do you have, I don't know, I accidentally grabbed the wrong summary.
It's okay, I'll take mine. Okay, from yesterday, though?
Yeah. Excellent. All right, we are going to start with Amendment L 53.
There is an amendment at the desk. Will the clerk please read L 53?
Amendment L53 to House Bill 1291. Amend the Business, Labor, and Technology Committee report dated April 22nd,
Senator Winter.
2025.
Thank you, Mr. Chair. What L 53 does is this is regarding the private right to action. So we heard a lot of concerns from the companies that they could be opening themselves up to litigation if a driver gave out a bottle of water or wasn't following some of these new policies. And so this very, very much narrows the scope of when a private right of action, when a civil suit may be brought, to only instances that result in death, sex assault, personal injury, except in cases where the victim's a minor. And it changes aggrieves to injured or harmed. And so this is very, 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 very much narrowing the definition of when a private right of action can be used. And I encourage a yes vote.
Senator Winter, would you please move the amendment?
I move L 53.
Seeing no further discussion, the question, Mr. Minority Leader. To the amendment.
Thank you, Mr. Chair. Process matters as we're seeking to develop policy, as we just discussed. We're all calling out the fact that we want to do this right. We want to create policy that we can live with. This amendment, I was just sent a picture, is one of many amendments that are lined up on a rail out there. One of those big, shiny brass rails that Chris makes sure are beautiful on a daily basis. One amendment after another amendment after another amendment that have just been received by the representatives of the businesses who are trying to get to a place where we can actually develop policy that truly is an answer of the tug and pull. It seems like there's just pull and pull. There's no, when you receive the amendments as the bill's being debated, the day before the end of the legislative session, and they're lined up on a rail out there and people are scurrying from amendment to amendment, each one which consists of dozens, if not hundreds of words that have to be understood. It's incredibly challenging to begin the conversation and believe that you're actually getting to a meaningful policy outcome. The reality is, we can say whatever we want to say. We can speak into the books whatever we want to speak into the books. That doesn't mean it can actually be done. We can speak into the books, gravity shall never exist, furthermore in Colorado. That doesn't make it so. We can speak into the books that a company will do A, B, and C, D, E, and F, and H, J, and K in that order, and the company may not be able to do that. And it just doesn't function. It just doesn't happen. And so for us to press forward, pushing something into the books that may or may not actually be functional is a pointless sophistry. Said another way, we're wasting our time. So I challenge the amendment simply because the amendment hasn't been vetted by the people who know how to vet, understand, and apply the amendment and give us honest feedback. Sponsors may think the feedback could not possibly be honest because of the injury that was once received. The reality is we cannot expect thoughtful feedback. Even if you don't want to call it honest, let's call it thoughtful feedback if you don't have time to think. And that's the circumstance we're in. Thank you, Mr. Chair.
Senator Winter.
Thank you, Mr. Chair, and thank you, Mr. Minority Leader. And I absolutely believe that Lyft has been working in good faith. We've met with them for hours on end. And with all due respect, Mr. Minority Leader, you got an email that I sent you on May 1st outlining many of these changes. I have a numerous page response right here on May 2nd with red lines and going back and forth on these amendments we are presenting that came from Lyft. And so we are late in session, and having the hard copies of the amendments might have come late, but nothing in these amendments was a surprise, and everything within these amendments was talked about for a while and agreed to for a while. And so we took stakeholding very seriously. And just because hard copies were brought out does not mean that we did not take stakeholding seriously. I urge a yes vote. This was a major concern, private right of action from the companies. And I ask you to vote yes on L53.
Mr. Minority Leader.
Thank you very much. I'll let the process argument go. Stated, my perspective is resolute based on the data and information I have to that argument. To this particular amendment, the limitation on the PRA, I appreciate any time that you limit a PRA. In my mind, the best private right of action, the best private right of action is no private right of action. So at the end of the day, I appreciate the fact that this is narrow, still too big in my mind. I oppose the amendment.
Is there any further discussion? Seeing none, the motion before us is the adoption of L53. All those in favor say aye. Aye. Opposed, no. No. Ayes have it. That amendment is adopted. Senator Winter.
Thank you, Mr. Chair. I move L61.
1 minute. There is an amendment at the desk. Will the clerk please read L61?
Amendment L61 to
Senator
House Bill
Winter.
1291.
Thank you, Mr. Chair. I move Amendment L061.
To the amendment.
Within the House version of this bill, it required that the companies provide the technology for the drivers. Essentially that, and we were asking the PUC to do rulemaking around that, but the companies felt like that implied or could implicate that they had to buy everyone an iPhone. And so we're just striking that whole sentence. We definitely do not expect the companies to buy everyone an iPhone or whatever they need to access the app. And so that was a very reasonable request, and I ask for a yes vote on L61.
Is there any further discussion of L61? Seeing none, the motion before us is the adoption of L61. All those in favor say aye. Aye. Opposed, no.
54.
Ayes have it, and L61 is adopted. Senator Winter.
Thank you, Mr. Chair. Yeah. I will be moving L054.
There is an amendment at the desk. Will the clerk please read L054?
Amendment L054.
Senator
to-
Winter.
Thank you, Madam Chair. This directs TNCs to establish policies that prohibit drivers and riders from offering food and beverages, and it gives enforcement authority to the PUC by allowing random compliance checks. So this, in the House version, was made much more mandatory and had harsher penalties. And so we are also cleaning up some other places. This allows the companies to remove driver or rider ratings that are motivated by bias. So this is giving more flexibility to the companies to watch those ratings. It strikes a provision about making driver and rider comment reviews viewable by other riders and drivers, and this was also a big request by the companies. And it prevents alternative dispute resolution in cases of sexual assault, sexual harassment, injury, kidnapping, or death. And so there was a lot of concern around the enforcement of these new expectations. And I do have to just say, we've had a lot of conversations about the food and drink regulation. However, we met several victims that were assaulted after having that bottle of water in their Uber or Lyft, even when that bottle of water seemed to be unopened. And so this was an important premises from the victims' groups. And so this entire amendment is in response to requests from the TNC companies.
Would you please move L54?
I move L54 and ask for a yes vote.
Is there any further discussion? Seeing none, the motion before us is the adoption of L54. All those in favor say aye. Aye. Opposed, no. Ayes have it. L54 is adopted. Senator Winter.
If you want to just tell Kristen to deal with that in a second.
There is an amendment at the desk. Will the clerk please read L55?
Amendment L55, amending
Senator
Ring-Gross
Winter.
Bill.
Thank you, Mr. Chair. I move L55.
To the amendment.
This extends the incident review time from 72 hours to 7 business days. This was also a request from the companies. It gives rulemaking authority to the PUC for a process around sharing profile deactivations between TNCs. And the reason we're talking about rulemaking within the PUC is that's where TNCs are already regulated. That's where their regulation lives and as a home, so that's nothing new. It requires the TNCs to provide an opt-in for complaints to receive updates on a driver challenge to a profile deactivation. And so the original bill said you automatically got an update on the complaint. We are now changing it to an opt-in. So that's less work on the companies. It requires TNCs to provide complaints to law enforcement within 2 business days of the request for materials or otherwise requested by the subpoena. This was also a big change that the companies wanted. So if there is a subpoena and it says they have 7 days to comply, they have 10 days to comply. So anyway, that was a request from the companies. It removes the requirement in the annual reporting by the TNC to include who is presumably at fault in cases of a motor vehicle accident. And so a big request from the companies was not having a report on motor vehicle accidents, and we are taking that out. It includes drivers under the consumer protections in this bill, and so this was a request from the drivers. And prohibition of arbitration in instances of sexual misconduct or sex assault, and it clarifies the right to a jury trial, and that is a narrowing of what would have been allowed from a jury trial before. So that was also another request from the companies. And I asked for a yes vote on L55.
Is there any further discussion of L55? Seeing none, the motion before us is the adoption of L55. All those in favor say aye. Opposed, no.
Sure.
Ayes have it. L55 is adopted. Senator Winter. There is an amendment at the desk. Will the clerk please read L 58?
Amendment L 58, amend
Senator
reading gross
Winter.
bill.
Senator Winter.
Thank you, Mr. Chair. I move L 58.
To the amendment.
This states that the driver has a duty to notify the TNC within 48 hours of entering into a guilty plea or judgment that would disqualify them from driving. And it also removes liability from the TNC for a driver failing to notify them. And so ultimately, one of the most important things this bill does is increase background checks and talks about what qualifies people to be able to drive. But we were saying in between those background checks, which are every 6 months, if you enter into a guilty plea, you should report back. We understand that not a lot of people are going to self-report back a guilty plea for something that they did, and so we wanted to make sure that the TNCs did not have liability from that driver's behavior, and that's what this amendment does, and I ask for a yes vote on L58.
Is there any further discussion of L58? Seeing none, the motion before us is the adoption of L58. All those in favor say aye. Aye. Opposed, no. Ayes have it. L58 is adopted. There is an amendment at the desk. Will the clerk please read L52? 62.
Amendment L 62, amend reading gross bill,
Senator
page
Winter.
13.
Thank you, Mr. Chair. I move L62.
To the amendment.
This is probably the most major change that we are making. This is opt-in for audio-visual recordings. How it came over from the House was mandatory. This is now opt-in for the writer and the driver. And this was a very hard amendment for the victims' rights groups and survivors to take, because you're very likely, if you are planning, just as we heard in the story earlier today, that probably wasn't the first time he did that, probably wasn't the first time he decided to do a sexual assault, but you're going to make sure, and so we wanted recordings to be automatic. This is opt-in now, and so for that gentleman that very much got into a car knowing what he was going to do, this is a hard one to take, but this was very important to, I think, some of you all and important to the companies.
Senator Danielson.
Thank you, Mr. Chair. I don't need to duplicate my co-prime's comments. But I wanted to stress the difficulty the sponsors, all of us, had in approaching the concerns from members of this body on this issue. Understand that when we set into this, this was the line in the sand. This is what I was referring to, one of the things I was referring to. Because what we're admitting is that a driver whose intent is to traffic, kidnap, assault someone is not going to create their own evidence. This is the thing we didn't want to have to give away. But we acknowledge there are concerns from drivers, there are concerns from the companies, obviously. There are concerns from civil rights groups. And so we can get there on this go-round to how to require the driver to film and still preserve these rights. This is something we did not want to have to compromise away, but to stress and to our colleagues' points, process matters. An example, one of the many, where we have gone way beyond the comfort level and accommodated the opponents, demonstrating our willingness to compromise. And acknowledging that this is tough for one of the sponsors on many levels, I think is not insignificant. And I just wanted to stress that because we might have alluded to it in the beginning. This is one of the enormous compromises that we're bringing to you today. So that you, and then you also understand how we have committed to the process of hearing out concerns and addressing those that we agree are reasonable, even if we didn't want to have to make them. Thank you, Mr. Chair.
Senator Simpson.
Thank you, Mr. Chair. And as somebody who really doesn't function in this space with these rideshare companies, was curious if, like, currently, do drivers have that availability to them? And it seemed like it would be something, like if I was excuse me, if I was a driver, I would want to, have my customers rest assured that if you're going to get in my ride, that I'm going to disclose. I'm recording everything, and maybe it's a helpful selling point. So I don't know if drivers have that ability currently to do that.
Senator Winter.
Thank you for that question. I really appreciate that. One company currently has opt-in audio and visual. One company has opt-in audio. We also extended the timeline to ensure that they had adequate resources to do that. We've been talking with the technology folks at Lyft about what this would take, and I do absolutely agree with you that this should be one of those, right, you can pick a silent ride, you can pick a ride with fun music, or you can set your settings. And I hope that in the future the companies say you pick a recorded ride, and I will always pick a recorded ride.
And isn't it what we have left in the bill is that the companies have to have the opt-in? Yeah, correct.
Senator Danielson.
Thank you, Mr. Chair. Great question. And again, what I want to be clear, what we're requiring of the companies now is that they have to have the opt-in. So the existing technology on their platforms, instead of it being optional now, even though it's still optional for the user, the company has to offer the opt-in, which is, I think, the very least that they could do.
Is there any further discussion of L62? Seeing none, the motion before us is the adoption of L62. All those in favor say aye.
Yep.
Opposed, no. Ayes have it. L62 is adopted. There is an amendment at the desk. Will the clerk please read L63?
Amendment L63,
Senator
amending Gross
Winter.
Bill, page 19, line 11 and 12.
Senator Winter,
Thank you, Mr. Chair. I move L63.
to the amendment.
This is the final amendment we are running today. Oh, never mind, just kidding. This is another amendment we're running today. This aligns the effective date for rulemaking by the PUC by changing the deadline for required rulemakings to November 2025. So this adds to the timeline of the rulemakings, which was also a request of the companies. And then I know this is going to be very popular. It strikes the safety clause and replaces it with a petition clause.
Is there any further discussion of L63? Seeing none, the motion before us is the adoption of L63. All those in favor say aye. Opposed, no. The ayes have it, and L63 is adopted. There is an amendment coming to the desk. There's an amendment near the desk. There's an amendment at the desk. Will the clerk please read L57?
Amendment L57, amending
Senator
Gross Bill,
Winter.
page.
Thank you, Mr. Chair. I move L57.
To the amendment.
This explains that the companies are not liable for claims resulting from a rider or driver profile deactivation. So one of the more important parts of this bill that remains in the bill is deactivation when there are complaints of sexual harassment, sexual assault, and what this does is it says that the companies are not liable, that should they deactivate during that time. And so this is another shield that the companies asked for to reduce liability, which much of these amendments we're doing is drastically reducing liability from the companies at their request, and I ask for a yes vote.
Is there any further discussion of L57? Seeing none, the motion before us is the adoption of L57. All those in favor say aye. Aye. Opposed, no. Ayes have it, and L57 is adopted. Senator Winter.
Thank you, Mr. Chair. I just want to make a comment on the number of amendments. I think it's always an interesting strategic conversation of, do you bring a longer amendment or do you bring smaller amendments in chunks so everyone understands what they're reading? So for example, last night on second reading debate, I had a longer amendment. That one got read at length a couple times to make sure we all understood what was going on. Today, I decided to bring smaller amendments in shorter chunks to clearly explain the changes we were making. And I want to make it very clear, the number of amendments does not indicate that this policy is not ready for prime time. The number of amendments does not indicate that this policy is not ready to move forward. The number of amendments indicates the hard work that has gone on over the last month since April 6th when this bill, well, and prior to April 6th, we had a bill April 6th, but we've been meeting with the companies since January. And these amendments reflect collaboration, they reflect compromise. It does not reflect that this bill is messy. And the number of amendments I brought so everyone could clearly understand what we were voting on and what was being added to the bill. Thank you.
If I may, Senator Winter, in so many ways you are a master of the process. Senator Baisley.
Thank you, Mr. Chairman. I want to address one issue that I think is would be a minor change, and I hope that it's received positively by the sponsors. Let me go ahead and hand in this amendment.
There is an amendment at the desk. Will the clerk please read L 29.
Amendment L29, amend Ringross Bill, page 6, line
Senator
14.
Baisley.
Thank you, Mr. Chairman. I move L29 to House Bill 1291.
To the amendment.
Thank you, Mr. Chairman. So this addresses the frequency of criminal history record checks. So it's something that I would hope that all of the operators would do, is to have the transportation network companies would all have a background check for anyone that is going to come on as a driver for them. I would certainly do that for the sake of my riders, my customers. And so that's right and proper. And this does not address that initial background check. What it does is it removes the requirement to have that background check repeated every 6 months. So that is a frequency that is, I think, is a little bit onerous for the transportation companies. It's going to cost quite a bit, and I don't think it's necessary to continuously come back for every 6 months for another one and another one and another one. So that's the simple request, is that this would detect the initial background check, would detect a bad actor, but 6 months intervals kind of injure businesses while not having any effect or very, very little effect, I would think. So I ask for an aye on L29.
Senator Winter.
Thank you, Mr. Chair. Thank you for the amendment. We are asking for a no vote on this amendment. When your business is putting people in cars with strangers, I think it is an extremely reasonable cost of business to require background checks. There are lots of places of employment that require and pay for background checks because it is a vulnerable population. Daycare centers. We've had a ton of conversations on this floor about sports coaches. But this, by definition, you are in a vulnerable situation. And oftentimes, the people most likely to be using a TNC are vulnerable. They might be a minor, they could be disabled, they often are intoxicated. And so I think it is a very reasonable request to say part of your business of putting strangers in cars together is to pay for background checks.
Senator Rich.
Thank you, Mr. Chair. And I rise in support of this amendment. I was going to ask the sponsors about this because I know that this is specific. It seems like it's more specific to Uber and Lyft, but when you get into a taxi, you're getting into a taxi with someone you don't know. When you get on a bus, you're getting on a bus, you don't know anything about that driver. And I'm wondering, how often do they do criminal background checks?
Senator Winter.
Thank you, Mr. Chair. I don't have the answer to the frequency, but I have some background. And when Uber and Lyft and other TNCs originally came to the state, I was here and in committee, and one of the biggest fights we had was that taxis do require background checks, and the taxi companies do pay for their background checks, and the taxi companies felt like that was unfair. And through negotiations, as legislation does, that's not where we ended up. I would say I know that transit agencies require background checks for their bus drivers, their light rail drivers. And so I think they are acknowledging this is a vulnerable population. I don't know the frequency, but they are doing background checks.
Senator Rich.
Thank you, Mr. Chair, and thank you for that response. But you don't know the frequency, so we'll be treating these businesses differently than taxis or anyone else that's a driver, because maybe those background checks are just being done maybe once a year or one time when they're hired. So I think that L029 seems appropriate so that everyone's treated the same, and I would ask for an aye vote on L029.
Is there any further discussion? Seeing none, the motion before us is the adoption of L029. All those in favor say aye. Aye. Opposed, no? No! The noes have it, and that amendment is lost. Senator Bright.
Thank you, Mr. Chair.
Is there an amendment coming to the desk?
There is pretty soon.
All right. Senator Bright.
I'm of the belief that regulations, laws, statutes provide the basic level of safety that we're looking for, and when we overregulate or we create too many laws or too many standards, then it arbitrarily drives the cost up. And I believe that also when we've under-regulated, when we haven't put together the laws, then we're just generally not safe. And so I've identified after reading through the bill a piece that I feel like can really help this situation.
There's an amendment at the desk. Will the clerk please read L37?
Amendment L37,
Senator
amendment
Bright.
gross bill.
Thank you, Mr. Chair. I move Amendment L37 to House Bill 1291.
To the amendment.
Thank you. So on page 6 of the re-engrossed version of the bill, line 16, this amendment proposes adding in just a statement that says, if a driver or rider intentionally obscures, manipulates, or prevents audio or video recording during a prearranged ride, the transportation network company is not liable for the subsequent incidences that occur during the prearranged ride. So the company would then be held harmless for intentional acts. And I feel like this follows through with the spirit of the law and what we're going for here with creating a basic level of safety and making the transportation network companies accountable for the things that they can control, and then very finally, carefully weaving through and making sure that we're addressing the very specific problems that we can. So I would ask for an aye vote on L37.
Senator Winter.
Thank you, Mr. Chair. I'm asking for a no vote on L37 because I think much of this was addressed except for the most egregious actions that would be hidden by this. So we already changed private right of action, liability, to limit it to murder, assault, sexual harassment, and kidnapping. And so now we are saying even if a driver or rider is intentionally obscuring, then we're still giving everyone a pass. And I think we've narrowed this so much. And in addition, one of the amendments we did run was ensuring that regardless of this, so this isn't the driver or rider intentionally obscuring, but we did ensure that if there is any technical reason that the audio or video is not working, the companies aren't liable, and that was at the request of the companies as well. So we've taken out the technological reasons, and we've narrowed private right of action, and so I'm asking for a no vote.
Is there any further discussion? Seeing none, the motion before us is the adoption of L37. All those in favor say aye. Aye. Opposed, no. No. The noes have it, and that amendment is lost. Senator Pelton.
Thank you, Mr. Chair. I don't normally sit on this committee, but I subbed in that day for the good senator from Woodland Park. This is a bill that's very much encompassed by emotion. We heard a lot of testimony from victims, and I'm all for the victims. You know, this is terrible what's happened to some of them. But a lot of times, in my experience, in the last 13 years, anytime policy is surrounded by emotion, it usually ends up being bad policy. There's a lot of good that these businesses do. I've used them whenever I go to an event that has a real hard time with parking. It just makes it that much more convenient. You don't have to mess with any of that, looking for parking, paying for parking. A lot of times you can pay for your Lyft for the same kind of money as you would pay when it comes to parking. So we heard a lot of testimony from independent drivers that work for these companies that they depend on this job, this income, to make ends meet, to do some things extra for their families. Are there bad actors out there? Sure. I don't know whether this bill would have stopped what happened to the representative or some of these other people because there was an imposter that was in the seat doing that job. But I think there's another part of this bill that I feel really needs addressed, and that has to do with the amount of penalties that can be levied by the PUC. So with that, Mr. Chair.
There is an amendment at the desk. Will the clerk please read L34?
Amendment L34, amend Ring-Gross Bill, page
Senator
21.
Pelton.
Thank you, Mr. Chair. I move Amendment L034.
To the amendment.
Yes, what this amendment does, it caps the penalties that the PUC can come up with, can levy for any kind of alleged noncompliance of this bill. It caps it at $1,000. We heard from one of the bill sponsors about how these companies have billions and billions of dollars. I don't think we need to be playing a class warfare with bills. And so with this amendment, I think it's a good one. It has enough teeth that it allows the companies to work on remedy, but yet gives the people some satisfaction that something is being done. So I urge approval of L034.
Senator Winter.
Thank you, Mr. Chair. I encourage a no vote on L034. The original introduced version of this bill had fines up to $100,000. And I also want to point out that the fines are established by the PUC. Currently, the PUC fines generally start at around $1,100, so this is saying this might be less important than other fines that the PUC does. And so I think that's inappropriate. And then the reason we set it from a range, and I want to be clear, it's a range, from 1,100 to 20,000 is in alignment, I'm so sorry, to the Colorado Consumer Protection Act, which these companies already have to abide by. And when we talk about enforcement of the Colorado Consumer Protection Act, it is very much compliance and fixing first, even before a fine happens. And it is very, very, very rare that under that there's a full fine assessed, but in the most egregious cases. And so this is giving, I think, a reasonable range. The PUC does this. I believe them to be competent people, and I think it's highly unlikely, except in the most egregious cases, it would ever get that high, and it mirrors another law they're already complying with.
Is there any further discussion of L34? Seeing none, the motion before us is the adoption of L34. All those in favor say aye. Aye. Opposed, no. No. The noes have it, and that amendment is lost. To the bill. Is there any further discussion of House Bill 1291? Senator Kaplan.
Thank you, Mr. Chair. Members, I've been listening. I was in on hearing this bill in committee. It is fraught with emotion, and sometimes I wonder if it doesn't cloud some of the things that we're thinking, all of us, not either side. So I've got an amendment here, just a second, Mr. Chair.
There's amendment being found and then
Yes.
finding its way to the desk.
I'm looking for a
We'll
jewel
be here
here.
soon. There is an amendment now having arrived at the desk. Will the clerk please read L33?
Amendment L33, amend reading gross bill,
Senator
page
Catlin.
17.
This amendment would extend the time frame with which TNCs or networks are given to develop multitude of new internal policies in response to this bill. Rather than a mere 30 days, the TNCs would have 6 months to develop these new internal policies. Businesses usually take a time to figure out what they need to do in order to meet the requirements that we that are not in business put on them. And I think this is one of those times that we've seen a number of amendments made, agreed upon by the companies and the proponents of this piece of legislation. And this one would give them an opportunity to set those new rules and regulations in place. It seems to me we could do those kind of things and still take care of the people. Under this bill, the TNC would be responsible for formulating 8 new internal policies within a month of the legislation's enactment. This seems unrealistic timeline for TNCs to dramatically shift their internal operations. We should not be contributing to aggressive disruptions on business procedures. This amendment would ensure that TNCs are given an adequate time frame with which to respond to the implications of this bill. I think one of the things that does say is, listen, we know that that you will do the things that need to be done to respond to this piece of legislation, but we also recognize that in business there are times that it takes longer than what legislators like me would think they need to take. So I would ask for a yes on amendment number 33.
Senator Winter.
I ask for a senatorial 5.
Granted.
Do it all at once. Thank you. Okay. Well, let's wait.
Senator Catlin.
Thank you, Mr. Chair. I'd like to withdraw amendment 33,
Amendment L033 is withdrawn.
and I have another one.
There is an amendment at the desk. Will the clerk please read L? 66, how appropriate that it is double the 33.
Amendment L66, amend reading gross bill page 17,
Senator
line
Catlin.
11.
Thank you, Mr. Chair. I'd like to Move Amendment L066 to House Bill 1291.
To the amendment.
And I would like, what we've done here is through gracious negotiations with the sponsor, we've removed the request for 6 months, and we're going to put a 3-month period in so that these companies would have an opportunity to conform to the requirements of this piece of legislation. I think that should help these companies as much as I possibly can in this situation. So I'd ask for a yes vote.
Senator Winter.
Thank you, Mr. Chair. I also ask for a yes vote on L66, which, yes, it's double the original L33, but half in the policy. But we already changed it from a safety clause to a petition clause, which extended essentially everything by 3 months. This extends it by 3 months, so it's 6 months total. And the full 6 months would have compromised some of the PUC rulemakings. And so I thought this was a reasonable request, and I am happy we got to agreement. And I ask for a yes vote.
Just delighted with the math. 6 months for 33, 3 months for 66. Is there any further discussion of this amendment? Seeing none, the motion before us is the adoption of L66. All those in favor say aye. Aye. Opposed, no. Ayes have it, and that amendment is adopted. Further discussion of House Bill 1291. Senator Liston.
Thank you, Mr. Chair. Well, members, I just wanted to say a few words. I appreciate what the sponsors have been willing to do, and for the amendments, they came fast and furious. It's kind of hard to keep track of them, but I could tell that some of the amendments will be more beneficial and reasonable for the TNC companies. I want to stress, just like all of us, anybody that gets into a TNC, we all expect good service and safety. That goes without saying. Unfortunately, in any industry, and I'm not making excuses, because there's many thousands of drivers out there, but in any industry, whether it's the TNC industry or just anything out there, you're going to have some unsavory characters. And I know the sponsors are trying to address that, and I'm sure that there are many of us that certainly go along and support that idea and that effort. However, I just wanted to, and I'm not making excuses, but I just wanted to mention, despite some of the small, minute number of TNC drivers, that the vast majority of the drivers do a good job. They're trying to do the right thing and treat their customers, the people who are there, very fairly. There's tens of thousands of people here in Colorado who really greatly depend upon the TNC industry. There's people who are blind, who are partially disabled, there's veterans, there's old people, there's young people. There's a whole swath of people that rely every single day on the TNC industry. And they are served very well by the vast majority. Here in the state, this is a recent information, there's almost 35,000 rideshare drivers as of April. And these roughly 35,000 drivers, just in April alone, earned over $60 million. Annualizing this out, the expected net income in 2025 would be almost $750 million. That's real money. That adds to the economy and the service here in the state of Colorado. And that's up from about $660 million last year in 2024. The other benefit to the TNC industry is the safety aspect. We've talked about that unfortunately, the few cases where there's not safety, but we also have to take into account the number of DUIs that have gone down significantly because of the TNC industry. In 2014, the number of DUI arrests were floating about 2,000 a month. But if you come forward to 2018, the number of DUI arrests went down from 2,000 to 1,700, and today the DUI arrests are about half of what they were 10 or so years ago. So clearly, it's saved a lot of lives, it's saved a lot of money for people. So I just wanted to, and there again, I fully support the concept of what the sponsors are trying to do, but the TNC industry is vital to Colorado's economy, and while I understand the impact of 1291, we don't want to inadvertently put too many rules and regulations that could potentially drive out the TNC industry out of Colorado, which would have an adverse effect. So there again, I appreciate what the sponsors have done and their willingness to compromise. I wish they, quite frankly, would have considered a couple more of our amendments, but maybe as things progress down the road, we can further refine this. So, Mr. Chairman, I just wanted to give a shout out to the vast majority of the good people in the TNC industry that are doing good service and safety and doing the right thing day in and day out. Thank you, Mr. Chairman.
Senator Winter.
Thank you, Madam Chair, and thank you for those comments. We have research that shows actually 19% of drivers have been assaulted or harassed in some way, shape, or form. And we've been having numerous correspondences with drivers after that contact, and we went through the bill with them and said, we're requiring some more background checks. We want to make sure that you can record your rides if you want to record your rides. We had a state employee that came down here on his own time because he drives for Uber on the side, and he was stabbed and almost bled out and sent to the hospital. And he's very much for this bill. So yes, the vast majority of drivers that work for TNCs are amazing, incredible people. They're some of the most hilarious, compassionate people I've met when I've used those services. And at the same time, I just want to reiterate, this isn't just about protecting passengers. This is about protecting drivers. And the drivers have also been saying, yes, please do this. I also want more safety. I want some safety baked in, and I don't want to be assaulted. So I agree with those comments. The drivers are amazing, and it's also one of the reasons we're doing this bill.
Senator Carson.
Thank you, Mr. Chairman. I'd like to talk about one provision in the bill which I'm very much in favor of. And I think my colleague from Castle Rock is going to speak about this as well, potentially among some other things, because it came up in a bill that she sponsored. The provision in here dealing with the companies needing to comply with subpoenas and search warrants in a timely manner, I think that's extremely important. And we ran into this issue with Senate Bill 86 with the social media companies, which in my opinion, unfortunately, is not going to become law this year. But I think it's an issue that we should continue to work on. But when these companies are not cooperating with law enforcement, it's a real detriment to everybody, because as we heard earlier about horrible crimes being perpetrated, law enforcement's got to be able to get to the evidence. The companies have to respond in a timely manner to subpoenas and to search warrants. And, you know, certainly as an attorney, I've always been under the impression that if you don't comply, if your responsibility as an attorney at a company is to comply with search warrants, subpoenas, and you don't do it, you can certainly have a complaint filed against you with the Ethics Committee. You could possibly be disbarred. I think what's happening here is in these big companies, you've got a real bureaucracy, and maybe you got a number of lawyers there, and nobody really seems to be accountable and responsible for this. And that's why I like the language in Senate Bill 86, sponsored by the senator from Castle Rock and the senator from Arvada, which really put some teeth in that and said, you know, you could be fined $20,000 if you didn't comply in a timely manner. And so I think down the road, we may have to look at things like that, because if companies are just sort of using this bureaucratic excuse, well, we've got, you know, we're trying to respond timely, yada, 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 and they don't even have a clear place where law enforcement and plaintiffs, I guess you would say, people who've been injured can even go to send the subpoenas and send the search warrants into. And again, that was set up very nicely in Senate Bill 86, where we were simply saying there, you got to set up a process, a hotline or whatever it is, where law enforcement can contact the attorneys working for the company and say, we've got this search warrant, we've had suspected criminal activity that occurred, and we need to have the information and the evidence. And so I just wanted to speak on that particular provision and thank the sponsors for including that. And I think it's something we're going to have to continue to look at on behalf of law enforcement and all of us to make sure we have a safer community. But if these companies are just dragging their feet, we need to take a serious look at that. So hopefully this will put some teeth into that process. So thank you.
Senator Winter and then Senator Frizzell.
Thank you, Mr. Chair. And I just want to thank the good senator from Highlands Ranch for those comments, because I think one of the most egregious things we heard was the amount of time it was taking survivors to get any information back, and the amount of time that it was getting law enforcement the information they need to conduct an investigation. When the response from the detective was, I don't know how long they're going to get back to me. It could be a week or over a month. And honestly, these companies aren't very quick at getting back to us. I think that was one of the bigger problems we saw. And so I appreciate the senator from Highlands Ranch highlighting the importance of that.
Senator Frizzell.
Thank you, Mr. Chair. And I want to say thank you to the bill sponsors for bringing this legislation, and mostly for working to amend this bill to get it into a place where it is good for riders, drivers, and business, because it is a tricky needle to thread. I completely understand that. And I really want to say thank you. Sex assault is never okay. Assault on another person is never okay. And the things that have been happening with ride shares, as reported in this conversation, are never okay. I cannot even believe my ears when I hear about some of the things that I've heard. The good representative from North Glen, what she had to endure is unspeakable and unforgivable, in my opinion. You know, I've used ride shares. My daughter uses them super regularly. My daughters-in-law And I think we all have this expectation that this is a safe environment. You're getting into a car, you see like the picture of the person and the picture of the car and their license plate, and you look for that, and you hop in and get to where you need to go until something, bad could happen. And I get, something bad can happen to you walking down the street. Life is uncertain. And I've received, and I'm sure you all have too, thousands and thousands and thousands of emails on this topic. Some from users, some from drivers, really talking about kill this bill because this is going to be bad. Uber is going to leave the state of Colorado. But this is a problem. It's not just for riders, it's a problem for drivers. It's a problem on both sides. And it's really, really critical that we acknowledge that. And I think that the bill sponsors have done a nice job of describing that. And I can't miss the opportunity to get up here and talk about page 12 of this bill, where it says, if a person files a complaint against a transportation network company or driver, the transportation network company shall respond, to a subpoena or search warrant for information related to the complaint from a court, the Office of the Attorney General, a district attorney's office, the commission, or a law enforcement agency, no later than 48 hours after the request is made. 48 hours. Does that sound familiar? Because it sure as heck sounds familiar to me. Imagine my disbelief, and I'm being super sarcastic here, imagine my disbelief to hear that a large internet company is disregarding subpoenas or search warrants from district attorneys. Imagine. Shocking. But I'll tell you what I heard from people when I was telling them about this particular section of Senate Bill 86, where it said, we started out at 48 hours. We had to amend it to 72 hours in the House, but 48 hours. And people said, well, what if they don't comply? What happens then? Because just like in Senate Bill 86, there's not a fine associated here. I guess the Attorney General can go after them at this point if they fail to respond. But I had people who were listening to this story about what had happened to people on social media, on Snapchat and TikTok. And they said, well, what if they don't comply? What if they don't respond? Can you issue a fine? What happens then? And the reality was no. The fact that we're having to have this conversation again blows my mind. Blows my mind. But it's something that we must take seriously in this building. I am pro-business all day long. But when we are at a point when people's safety is at risk, when we have companies who are disregarding the law, we have a fundamental problem. And it's incumbent on us, if it's not going to be taken up federally, then we need to do it here in Colorado to keep our citizens safe. So I'm not here to lobby for a bill that was killed by the governor, but I am here to lobby for more awareness around this issue because it's something that we need to take seriously, and I will be taking this seriously next session. I would again like to thank the bill sponsors. And thank you for your time.
Is there any further discussion? Senator Danielson. Senatorial 5. We're back, and we've got Senator Danielson. There's an amendment at the desk. Will the clerk please read L68?
Amendment L68,
Senator
amendment reading gross bill.
Danielson.
Thank you, Mr. Chair. We earlier today adopted L61. However, when we were working with the various interested parties, we accidentally erased some critical language around undue burden from purchasing technology, the undue burden being on the drivers. And so we'd already committed to inserting this language in what ended up being Amendment L61. And so I move L68 to ensure that the driver doesn't suffer any undue burden from purchasing technology to enable the audio and video recording. Again, these were concerns that we heard from members of this body, but directly from members of the community, people who drive, who thought, okay, well, we're fine with the concept, but we shouldn't be required to purchase dash cams, et cetera, because it's not right. So this squares that, and I urge an aye vote. Thank you.
Is there any further discussion of L68? Seeing none, the motion before us is the adoption of L68. All those in favor say aye. Aye. Opposed, no. Ayes have it. That amendment is adopted. Is there any further discussion of House Bill 1291? Seeing none, the motion before us is the adoption of House Bill 1291. All those in favor say aye. Aye. Opposed, no. Ayes have it, and that bill is adopted. Mr. Majority Leader. Mr. Majority Leader.
Thank you, Mr. Chair. I move to lay over the balance of the calendar for,
Nope, just rise and report. That's all that's on the
thank
calendar.
you. Like to rise and report.
Motion is to rise and report. All those in favor say aye. Aye. Opposed, no. Ayes have it. We will rise and report.
Senate will come to order. Senator Bridges.
Thank you, Mr. President. The committee has met and had a number of bills under consideration, one being that number. Will the clerk please read the report?
May 6, 2025. Mr. President, your committee of the whole begs leave to report it has had under consideration the following attached bill being the second reading thereof and makes the following recommendations thereon. House Bill 1291 as amended passed on second reading in order revised and placed on the calendar for third reading and final passage.
Senator Bridges.
Thank you, Mr. President. I move the report.
The motion is adoption committee of the whole report. Are there any no votes? Senators, Mr. Minority Leader. With a vote, Senator Peltonar. With a vote of 33 ayes, 2 noes, 0 absent, 0 excused, committee of the whole report is adopted. House Bill 1291 is amended, passed second reading, order revised, passed kind of third reading and final passage. Majority Rodriguez. Governor's Committee report. Conference Committee reports. I was like, what are you?
Your first conference committee appointed on Senate Bill 155 concerning the creation of an advisory council for persons who are incarcerated has met and reports that it has agreed upon the following. That the Senate accede to the House amendments made to the bill as the amendments appear in the revised bill with the following changes. Respectfully submitted, Senate committees, Senators Gonzalez, Chair, Ball, and Carson. House Committee Representatives Clifford, Chair, Garcia, and Soper. Your first conference committee appointed on Senate Bill 37 concerning assistance for communities experiencing energy transition has met and reports that it has agreed upon the following. That the Senate accede to the House amendments made to the bill as the amendments appear in the re-revised bill with the following changes. Respectfully submitted, Senate committee, Senators Roberts, Chair, Hendrickson, and Kirkmeyer. House Committee, Representatives Taggart, Chair, Morrow, and Lukens.
Mr. Schaffler, please excuse Senator Exum. Signing of bills.
The President has signed House Bill 1108, 1175, 1177, 1207, 1211, 1225, 1239, 1272, 1290, 1301. House Joint Resolution 1026, House Joint Resolution 1027, House Joint Resolution 1028, House Joint Resolution 1030. The President has signed Senate Bill 1, 2, 53, 128, 168, 179, 203, and 268.
Third reading of bills, final passage. Majority Leader Rodriguez.
Thank you, Mr. President. I move the Senate proceed out of order to take up House Bill 1312.
The motion is proceed out of order to take up House Bill 1312. All those in favor say aye. Opposed, no. The ayes have it and proceed out of order to take up House Bill 1312. Mr. Schaffler, please read the title of House Bill 1312.
House Bill 1312 by Representatives Garcia and Stewart and Senator Winter and Colker concerning legal protections for transgender individuals.
Senator Winter.
Thank you, Mr. President. I move for third reading and final passage, House Bill 1312.
Further discussion. Senator Pelton R.
Thank you, Mr. President. I mentioned last night that since this bill was introduced, I've had more discussions around this bill than any other. I've had more emails on this bill than any other, and I heard 003 in committee. So I got a lot of emails with 003 for committee, for the floor, and since. But this bill, by far, has generated a lot of conversations. I was going to read 2 emails last night that I got permission to read. I only read one last night because of an interest of time. So I'm going to read the other one this morning. As an unaffiliated millennial mom of 4 school-age kids who's lived in the Denver area for about 15 years, I'm writing to beg you to vote no on 1312. Although I feel simply for the deep emotional struggles of transgender people, this bill is an egregious and authoritarian violation of free speech, religious freedoms, and parental rights. It has no place in a free society. If passed, it would certainly expose our state to many costly legal battles and eventually be overthrown in court as unconstitutional, but not before irreparable harm was done to Colorado families and the state itself. There are many reasons to oppose this bill. Dictating to people which words they can or cannot use, pronouns or otherwise, is totalitarian regardless of good intentions. If some people choose not to validate gender identities with pronouns or names, the state cannot mandate that without repression. It's like trying to force everyone to join the same religion. Actions may be compelled. Hearts and minds must be one, and cursed words aren't real validation. Anyway, if one is sure of one's identity, why would one need verbal validation so badly that one would force another to give it unwillingly? The bill would legalize the oppression of religious, parentheses, Jewish, Christian, and Muslim, for example, schools, groups, and individuals who see biological sex and gender as immutable and would then be thought policed. It would make Colorado an unbearable place to coexist for many. Although some of the alarming provisions of the bill have been stripped, it's still deeply troubling, meddling in the very personal, complex, and individualized interactions between parents and children in an overreach and more than the state government is capable of effectively managing. With all due respect, we're talking about children who don't even know. It is hubristic and frankly insulting for legislators to think they know better than loving parents what's best for kids. Passing this bill would alienate a large group of moderate voters. The people I know who oppose it are highly educated, affluent professionals, business owners, and intellectuals. They buy organic food and pasture-raised eggs, bake super dough, and play classical music in their cars for their kids. They contribute a lot of taxes. My partner and I both hold master's degrees. The vast majority of the many Colorado parents who know in our demographic share our view on this. We see the bill as a threatening signal that our state legislators might not respect our ability to raise our kids as we see fit and everyone's ability to live freely according to their convictions. If the bill passes, these people will sue, they will vote out its supporters, or they will just leave. Economically, an exodus of productive, stable families would be disastrous. That has already been happening, and it's not sustainable. Schools are closing. The housing market is slowing down. There's a growing trend of people leaving Colorado, with more people moving out than in for economic and political reasons. Our economy has been growth dependent for many years. Exasperating the exodus could lead to a prolonged and painful statewide recession. It is the worst kind of ideological duplicity to use self-actualization, non-discriminatory, or diversity to justify silencing, marginalizing, and ironically discriminate against people who represent diversity of viewpoint. We can be kind to trans people without trampling on the rights of others to speak, believe, or parent as they choose. If you value freedom, inclusion, and diversity, then protect them. Please exercise better judgment than your House counterparts and kick this draconian bill to the curb. I've come down to the well a couple times and quoted some scripture around this because I believe God doesn't make mistakes. He gives you the sex when you're conceived, and he does it for a reason. And for those reasons, I cannot vote for this bill. Thank you.
Senator Bright.
Thank you, Mr. President. House Bill 251312 is a measure that, while presented as a shield for transgender Coloradoans, risks harming the very children it claims to protect. My heart is with every young person struggling with their identity, and I share the commitment to ensuring they feel safe, supported, and free to live authentically. But after careful review, I'm convinced that 1312 prioritizes ideology over evidence, endangers minors with unproven treatments, undermines parental rights, and invites reckless medical practices into our state. This bill is not the answer that we're looking for. I urge you to reject it for 4 critical reasons. It redefines parental caution as coercive control, shields experimental medicine from accountability. It forces schools to socially transition students without parental consent, and it mandates coverage for high-risk, unproven treatments. House Bill 251312 weaponizes family dynamics by classifying, dead naming, and misgendering a child as coercive control in custody disputes. This means a parent who questions their child's choice of sudden gender identity shift or hesitates to endorse irreversible medical interventions like puberty blockers or cross-sex hormones could be penalized, potentially losing custody of their own kids. This is not support for families. This is not love. It's state overreach into the sacred parent-child bond. International medical guidelines like those in Sweden and Finland prioritize psychotherapy over medicalization for minors with gender dysphoria. Yet this bill punishes parents for aligning with this cautious, evidence-based approach. This bill shields experimental pediatric medicine from accountability by prohibiting Colorado courts from enforcing out-of-state child welfare laws that restrict gender-affirming care, even when those laws reflect federal and international guidelines. This opens the door to interstate medical tourism, inviting families to seek treatments in Colorado that are restricted elsewhere for good reason. Puberty blockers are linked to bone density loss, cardiac issues, and are likely no more effective than a placebo for improving mental health. European nations like the United Kingdom have curtailed these treatments for minors due to the insufficient evidence of safety and efficacy. House Bill 1312 positions Colorado as a haven for procedures deemed unsafe abroad, prioritizing ideology over child welfare. Our state should not gamble with children's health to score political points. House Bill 1312 mandates that schools socially transition students without parental consent, requiring gender-neutral dress codes, and the use of chosen names and pronouns without notifying families. This bypasses parents who know their children best in decisions about identity that can have profound psychological and medical implications. International guidelines emphasize mental health support to navigate these complex feelings, not school policies that exclude parents. By mandating this approach, the bill erodes the trust between families and educators, placing children in the middle of a cultural debate they're too young to fully understand. We should be uniting families, not driving wedges between them. Colleagues, I ask you to reject this bill, not out of fear or prejudice, but out of a commitment to our children's health and future. Let's align with the growing global consensus that calls for caution, not haste, in treating gender dysphoria in minors. Let's protect parents who seek to guide their children with love and prudence. Let's demand accountability from the medical providers and prioritize evidence over ideology. Our children are not experiments. They are our responsibility. House Bill 1312 fails them by rushing to codify contested practices that would cause irreversible harm. Please vote no on this bill and let Colorado lead with compassion, clarity, and care.
Members, I just want to remind you, and I've do my best to be lenient, but we want to make sure that in our conversation we're not impugning motives. We want to speak specifically to this bill and not other policies. Senator Henriksen.
Thank you, Mr. President. We hold these truths to be self-evident, that all men are created equal, they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. That single sentence, which all of us know, which every American should know, holds the foundational principle that gave life to our nation. We've never fully lived up to it. No nation ever fully has. No nation ever fully can. But our greatness, the greatness of any society, is conditioned upon the willingness of that society to pursue those truths, which indeed are self-evident. And so from time to time, it has become necessary to take a chisel to the asterisks of our foundational statement. The caveats that say, yeah, but men, get yourself some land. Once you do that, that's when life really begins. Yeah, but liberty wasn't designed for slaves. Yeah, but the pursuit of happiness for women is best determined by her husband. We have struggled mightily with that precursive clause, the one that says we're all created equal, and we've used our discomfort with it to strip the subsequent clause that everyone is endowed by their Creator with certain inalienable rights, that among those are life, liberty, and the pursuit of happiness. But our nation has always, without fail, been better when we've affirmed the equal creation of all of human creation. And throughout human history, when societies have failed to affirm that precursive principle, human tragedy has always ensued. Our nation is wrestling with our commitment to this principle today. The civil rights question of our time is a question of biology versus ideology, a question of science versus choice, because it's far easier to deny the equal creation of our neighbors if we can deny their creation, their being altogether. I grew up under the belief that homosexuality, bisexuality, pansexuality were choices. Many Americans still believe this despite an overwhelming body of science which shows clear as day that our sexual orientation is in our DNA. And just as there is a documented history of trans and non-binary individuals existing since the beginning of human civilization, there's an overwhelming mountain of scientific research concluding that gender identity is also in our DNA. I'm not going to regale a list of the studies or go into the details of the findings on exome patterns, genome patterns, and DNA sequencing. The body of evidence is out there. Whether or not one pursues it or accepts it is a choice. What is not a choice is that nobody has chosen to be trans any more than I have chosen to be a cis man. I made as much of a personal choice as any of my trans or non-binary neighbors did, which is to say, I didn't make a choice at all. And so we have before us a bill that asks us to again consider our commitment to the precursive clause of our founding. Are we all created equal? And this bill declares unapologetically that the answer is yes. It's a resounding affirmation of our foundational principle, and what flows from the bill, having answered that question in the affirmative, are the requisite safeguards that ensure that the subsequent clause of our founding reflects our affirmative commitment to that precursive clause, the one that speaks of life, liberty, and the pursuit of happiness. Because liberty and happiness, the kind that affirms life and makes it worth living, cannot happen unless and until we are able to be seen and accepted for who we are. House Bill 1312, in its amended form, ensures the right of Coloradans to change their name regardless of their gender identity, and be called by that name on official documents, at school, and in the workplace. It ensures Coloradans aren't policed on their expression of themselves through the type of clothes that they wear relative to their gender identity. It ensures that Coloradans are not discriminated against in matters such as housing, employment, or health care on the basis of who they are, on the basis of the way that they were born, perfect and equal, as we all are. I'm disappointed by what has been removed from this bill, protections that are very necessary, protections that we should not rest on, but rather continue to pursue relentlessly. I hope to be a part of those efforts, but for today, I wanted to celebrate the progress that we stand on the cusp of, and realizing that this is one of only a handful of bills that I'll remember 50 years from now, should I still be on this earth. I didn't want to just wait and silently vote on one of the most significant issues of our time. And so I'm asking for an affirmation of American greatness. I'm asking for an affirmation of the conviction that all are created equal. I'm asking for a resounding recommitment to life, liberty, and the pursuit of happiness. I'm asking for an aye vote on House Bill 25-1312.
Senator Rich.
Thank you, Mr. President. And I don't come down here too often on third reading, and I don't have that much to say about this, but one of the first things I'm going to say is something I said yesterday. And the government, it will never love your children. And what I mean by that is that with a bill like this, when someone is convinced or coerced into believing there's something else, and they go through a lot of therapy and surgeries and things like that, and then realize they made a mistake, it will not be the government that is there to comfort your children. The government will never love your children. And the government is making a decision today that I will never forget, just like the previous speaker said. I will never forget this bill, and I will never let my constituents forget this bill. I am still getting emails about this bill today, even while we're here on the floor. I think this bill is shameful, and it is a direct assault on the parents I came to this chamber, I came to the legislature to do no harm. And it breaks my heart that this bill is going to do more harm than I ever thought the Colorado legislature could do. I will be a no vote on House Bill 1312.
Senator Bridges.
Thank you, Mr. President. I felt called to come down here today because I didn't want the debate on this bill to leave the impression that there was only one particular religious perspective on this bill, and that perspective was a no vote on this bill. That's not the case. Last night, a loving mother of a trans kid was outside these chambers and pinned a little butterfly on my suit jacket. And I noticed the cross hanging around her neck. And we had a really nice conversation about how her pastor came and testified in favor of this bill. She did not see her faith as calling her to oppose this bill. I don't see my faith as calling me to oppose this bill. I was married by the first transgender Episcopal priest in the world. A colleague from Cheyenne Wells said that God doesn't make mistakes. And God didn't make a mistake when he made her trans kid. In the name of compassion and care and love, I ask for an aye vote on this bill.
Senator Frizzell.
Thank you, Mr. President. So I don't know about you, but I am still shocked at the number of people who were listening to us yesterday, late in the evening, as we debated House Bill 25-1312. I was receiving texts from constituents, emails, all through the night. And in the words of Hannah from Parker, this bill is a massive threat to parents. The destruction of the family unit, the trust between parents and their kids, is the destruction of our future. And I talked about that yesterday. I talked about how deeply I disagreed with putting the state between parents and their children, or putting schools between parents and their kids. You know, those of us who are parents in this room know that it's hard. Being a parent it's the greatest joy, but it's hard. There are days, right? And kids today have it rough. In association with other bills that I've been on this session, just the exposure to a wide variety of things that are not great for kids, but that are available to them through social media and other online content have changed what being a child is. Completely changed it. I joke that my now three-year-old granddaughter Ari can pull up a CoComelon video on an iPad faster than I can access my email, and that's real. You know, technology brings many gifts, but it also brings many dangers as well. And I often wonder if we shield our kids well enough from those things. But in speaking, and as that relates to this bill, raising children has changed a lot since I was raising my kids. They are exposed to so many other things in school, so many outside influences that as a parent, I used to be able to really control. I was the gatekeeper, right? And probably some of you whose kids are old enough, you were the same. My parenting philosophy was teach them how to make great decisions, because ultimately I'm not going to be there forever to make decisions for them. And I think that for that time was probably good, but I think that there's a lot more involved with it today. You have to, as a parent, have that bond. You have to have that relationship, that trust. And I fear in my heart that relationship is being eroded and has eroded. And it's not just one thing, it's many, many things. So when Hannah sent me an email saying, the destruction of the family unit, the trust between parents and their kids is the destruction of our future, I believe it. I believe it so strongly that I'm here saying those words to you. I appreciate that the bill sponsors have significantly changed the direction of House Bill 251312 from when it arrived in this chamber. I appreciate that. But it is still a bill that represents a dangerous erosion of parental rights. And I base that a lot on Section 7. And I think, we'll have some of my colleagues will be up talking about this, but really creating a scenario where a parent's decision to love their child through issues that they may be having, real or imposed from outside influences, could be deemed discriminatory. I feel like that's in here. Or that somebody else's belief that that's improper could be deemed discriminatory. I think the children and parents need to be having these conversations without us interjecting ourselves into that arena. So, members, I appreciate the work of the bill sponsors. But I still don't view this legislation as a positive thing for families in the state of Colorado. And as such, I will be a no vote today. Thank you.
Senator Catlin.
Thank you, Mr. President. Members, I'm here today to talk about being a senator. I get emails. I just got one from a lady that needs me to help her with her driver's license and getting it renewed and all of the things. People contact me for help, whether it be with DMV or whether it be 1312. And I've had a lot of contact on 1312. Everybody has told you that, and I'm just like the rest of my caucus. There's been a lot of emotion over this, and a lot of confusion, and people asking me why. Will you please do something to stop this? Well, you know, folks don't really understand how things work here. But I am here today to talk to you about when I found out that I was going to be a parent. You know, that kind of changed everything that day, because I stopped thinking about myself first, started thinking about who was coming to join my family. You know, I had no idea what was coming at us. I had an idea what it would be like. But as a parent, I had to deal with a number of things that came up, everything that came up in their life. Sure, I would allow them to take decisions that their age would allow, pick the color of socks and put their clothes on to go to kindergarten and maybe look like crazy, but they made that choice. And it helped them to be able to make choices that would be good for them at that age. But it seems what we're doing today is inserting institutions that may not understand that picking polka-dotted socks and striped pants is okay for today. But try not to do that for the rest of your life. And when it comes down to this, the gender, that's a complicated situation that probably mom and dad and the child all probably need to talk about. And if there is need of help, the parents would find the help and be involved in that. That's why we're given the gift of children. They are a gift. And I don't want to trade off anybody's responsibilities for that gift. And honestly, I do believe that they are a gift. Now, they're the gift that keeps on giving too much every once in a while. But they're my gift. They were given to me. And my responsibility is to give them a life that they can go live happily, healthily, and be able to do life the way life should probably be lived, regardless of what happens in their mind regarding their gender. Because that would be a mountain to climb. If somebody decided they wanted to change. But that should be a journey that's taken by all of us in that household, mom, dad, and the child. Because we don't know what that journey is going to look like. And sometimes just holding a hand helps with the journey. But if institutions become involved, now mom and dad have to deal with the institution too. And sometimes there's not enough space in people's minds, lives, or hearts to deal with someone outside that family. 1312 worries me in that, because others want to help me make the decision, me, the parent, make decisions for the child that I'm going to leave here. And I honestly believe the only thing that I'm going to leave in this world is the kids that I raised. Regardless of what my net worth is or how many acres I've got and all those kind of things, the people I leave behind me are going to be my legacy. And I want them to be happy, healthy, and successful. And in this modern era, that may take more work than what it took raising mine. I can tell you today that I'm very glad that I grew up when I grew up. I would hate to be a child today. There are way too many pressures on young people, way too many, whether it comes from social platforms or whether it comes from peers, or whether it comes from institutions. There is too much pressure. I can't do anything about that today. But I can tell you that I honestly believe that children are given to us as a gift. We should not spoil that gift. And if decisions are made that want to change the way life is lived, that should be something we do together, not outside the purview of mom and dad or the people that care the most. And the other thing about 1312 is that it feels like I'm going to be forced to say words, forced to use language that I'm not comfortable with. The new etiquette of the world was evident to me last night. I went home to talk to my family about what we had done over the evening. And a young man started listing the different things I needed to be talking about in regards to talking about this. And it struck me. I'm nowhere caught up on what we're going to talk about or how I'm going to address you. Or if I'm addressing someone that was in this situation yesterday and they're in that situation tomorrow, I may have made a mistake because I addressed the person that I knew yesterday. And that's happening to each and every one of us, but we're not positive about it and we don't see it happening. But it's happening. Categorizing people, where they live, what they stand for, how they look, all of these things. We are just getting to the point. We make a list of the people that fit these categories. And then it's my responsibility to keep track of the category. And if I fail, I may be held accountable. When it was not I didn't do it on purpose. I didn't even know it was a fact. But it's now a fact. A fact that was slipped in under me before I even realized we'd changed the rules. It worries me when legislators start thinking that we can change the rules and not have to say to anybody we changed the rules. Can't call this person that anymore, you got to call them this. Because of a decision they made. You know, I try to be a friendly person in this Capitol building. You know, I don't hold grudges too much. I greet people the way I see them and those kind of things. But after the discussions last night, it made me wonder, should I look a lot closer at saying, "Good morning, sir, how are you?" Maybe just leave off the "sir." And I don't want to get carried away with all of these kind of things, but it's something I think we should be thinking about. Because I can tell you the people outside this building and the people that stayed on the stream until we were done, they're paying attention.
Senator Catlin,
Yes, ma'am.
you have 52 seconds left. Would you like to continue or on your second 10 minutes?
I'm going to finish up right here.
Okay.
We need to make decisions for the people that are out there that care, that are worried, and that are scared stiff. These folks are doing the best they possibly can. And I'm very proud of them being parents because they're making decisions all across the board, not simply for those that are wanting to change, but the people that they're raising. What I'm going to try to do is be the best legislator that I can be for them. Please vote no on 1312.
Senator Simpson.
Thank you, Madam President. A few thoughts this morning or this afternoon about this policy in the bill, and a heartfelt thanks to the sponsors. I know where their heart is and what we're trying to accomplish in this space. Was kind of actively involved in this conversation last year as part of a political campaign where references to other folks active in this role of desire to represent people in Senate District 6. There was what I would characterize as some identity politics and discrimination that, immediately and with conviction condemned, that this is really, I think it aligns with what we're trying to accomplish in this policy. I do think at some point the policy, from my perspective, diverges a little bit and treats, or I have concerns about how it treats adults versus how it treats children. I think there is an avenue that, well, I know there's an avenue from my perspective that raises an abundance of concern about children and their identity and their potential discrimination and how kids are treated in schools in particular. I can't help but think, all during this conversation, my wife and I's only son, who will be 34 this month, when he was 8, he declared he was changing his name to Titor. Now, I don't think that had anything to do with gender identity. I don't even recall. It was probably some superhuman thing, Pokemon, or I don't know what it was. But even to this day, he'll be 34 next month. I still have friends of the family that still refer to my son as Titor, and trying to work through the complexities of how had that unfolded in this environment today. Is there, risk and potential challenges as a parent? It's a nuanced conversation. This is a nuanced policy that I've approached like I have every other policy, trying to be very thoughtful, engaged, and try to represent my communities in this state very well. I just cannot get to a support position really because of what I think is an avenue that creates a division in the family unit in the state, potentially interjecting itself in that very important family cohesion and environment. And that part of it is very troubling and challenging for me. And for those reasons, today I will be a respectful no vote on House Bill 1312. Thank you, Madam President.
Thank you. Senator Lundin, Mr. Minority Leader.
Thank you very much, Madam President. Colleagues, thanks for your attention to this. I love the Senate. I love the fact that we pause, at least on third readings, at least usually, to think about, listen, actually process what's going on. And as I listen to the conversation and think back to the second reading debate, which moved very fast with lots of amendments yesterday, and consider what I'm hearing today, it occurs to me with great clarity we are having what is classically called an AM-FM conversation. We're talking right past each other. And you don't have to go any further than the short title of the policy to understand what's going on. The short title of House Bill 25-1312 is the Kelly Loving Act. Kelly Loving was an heroic 40-year-old trans woman who put herself in between her friends and fire. 40-year-old who sacrificed her life for the benefit of her friends. That is the call out of this particular act. And the arguments that you have heard strenuously over and over and over again from the non-sponsorship side are all about children. Not 40-year-olds, not even 18-year-olds, but children still in the protection of the circumstance that we call custody. It's that big of a deal. We use the word custody to describe the relationship and responsibility between parents and their children. So my comments will continue in that vein. They are the reason of my opposition. I would say the bill as presented was extreme in the extremis. It was beyond the beyond. And now it's been reduced and reduced and reduced with 3 major amendments and a few smaller amendments to just be what I will describe as suboptimal, the word we typically use, although it's a philosophical word and doesn't therefore have the precision that I wish it did, bad policy. While intended to protect transgender individuals, sponsors are thinking Kelly Loving, 40-year-old hero, this bill introduces significant risks of government intrusion into the sacred, that's a considered word for me, parent-child relationship. My concerns focus on the bill's school policies, their conflict with existing Colorado law, and the enforcement mechanisms involving the Colorado Civil Rights Commission and Division, which threaten in a critically important way, even now as amended, parental rights and draw the state into personal family matters. Additionally, the bill's redefinition of speech related to chosen names as potentially discriminatory creates new threats to free speech. We heard a very eloquent speech about founding documents and freedoms that are inherent in this experiment that is America. This bill, in my opinion, considered opinion with logical support, not just an emotional flyer, is a risk to freedom of speech and a potential threat, coercive, word removed from the bill, but I would argue still inherent in the policy, coercive, mandated speech, antithetical to who we are as Americans. Section 6 of House Bill 1312, and to be clear, colleagues, I'm working from the revised as of last night with all of the amendments in it to today. So the bill that we had, the pre-amended version May 5, has now been overcome in the last several hours by the revised version of House Bill 251312. That's the one I'm referring to. Section 6 of the revised bill, codified as CRS 22-1-145.5, mandates that if a local education provider adopts a policy on chosen names, it must be inclusive of all reasons, whatever reason you want. Make it up out of thin air if you want, or have a considered deep purpose. But the policy says all reasons. That can come out of thin air. And I'm not saying that will always be the case, but that's what we're putting into the law. A student might adopt a name different from their legal name. It goes back to the Pokemon name we were just hearing about a few moments ago. This requirement conflicts with settled Colorado law. What we have said and we have year after year allowed to remain in the law books and not changed. Here's the considered Colorado law. I refer you to 1322-107. Parents have a fundamental right and responsibility to make decisions concerning the care, custody, and control of their children. The law has long presumed, I'm reading from the statute book here, and it's referring to preceding law. The law has long presumed that parents act in the best interest of their children. Parents make conscious choices every day on behalf of their children concerning the risks and benefits of participation in activities that may invoke risk or involve risks. These are proper parental choices on behalf of children that should not be ignored, says the law. So long as the decision is voluntary and informed, that would be the parents being voluntary and informed, the decision should be given the same dignity as regarding schooling, medical treatment, and religious education. That's what the settled law says. We believe parents are important, authoritative, fundamental. Why? Well, it goes back to the word I used to describe the parent-child relationship. Sacred. It has thus always been so. And as I acknowledged on the mic last night, there are situations where it's broken. It doesn't always work that way. But generally, almost always, it does work that way, which is why 1312 is such a policy offense to me. The rights as codified, affirmed in the statute, are fundamental to parents' ability to direct the education, the upbringing, the care of their children. As the bill proposes, by compelling schools to honor a student's chosen name potentially without, and it has been meted out in behavior, potentially without, frequently without, not always, but frequently without parents' notification or consent, this provision in 1312 risks enabling schools' ability to facilitate a child's social transition in secret, hidden.
Mr. Minority Leader, you have 45 seconds left. Would you like to continue on to your second 10 minutes?
I thought as Minority Leader I got 45 minutes.
Oh, yeah, we changed that.
Fair enough. I will take my second 10 minutes and
Okay,
light a fire under it.
go for it.
For example, a student might adopt a chosen name tied to gender identity, and parents could remain unaware of these significant changes affecting their child's emotional and psychological well-being. This undermines the trust essential to that sacred parent-child bond. Positioning government, in this case, it's schools, but it's government, by positioning government as intermediaries between parents and children in critical family decisions. Section 7, again, referring to the revised, further compounds these concerns by requiring school dress codes to allow students to choose any option provided without regard to gender. This mandate may clash with parental values or significant cultural beliefs about appropriate attire. Now, that is not so present in this moment in Colorado, but there are other states in this country where there are growing, expanding cultures that are very significantly tied to headwear, to the specifics of what the attire of the children may be. And it's fundamentally important to the family, to the parents, with regard to their beliefs about what appropriate attire is. This bill intrudes into that familial conversation. Parents guiding their children's clothing choices to align with family principles would very likely find themselves at odds with school policies, inviting state intervention to enforce compliance. So now we've got the state, by virtue of the government school, intruding into that familial decision and saying, no, that's not what will be allowed here. This risks sidelining parents from decisions about their child's expression, further eroding their authority. Moving on to sections 8 and 9, again to the revised bill, current form of the bill, not talking to something that has been wiped away, but it is the law as it would be, passing out of here, headed back to the House for reconsideration. Sections 8 and 9 of the amend the Colorado Anti-Discrimination Act to include chosen name. Chosen name, that's a specific called out quote that's in the law, within the definition of gender expression, and establish the Colorado Anti-Discrimination Act as the framework for addressing related complaints. By defining the failure to use an individual's chosen name as a potentially discriminatory act in the public accommodations law, including schools, these provisions empower the CCRD to investigate and adjudicate complaints. We've seen this movie before. When you have a judge jury and executioner, things get out of whack. And now we're putting that into this law in enforcement by an advocacy organization. For instance, a parent who uses their child's legal name to maintain consistency or address concerns about rapid identity changes could be reported for failing to use the chosen name, triggering a state investigation. Family has an investigation in the household, potentially. Parents are under investigation because the teacher has said, and they reported it. I mean, that's down the road. It's not in this bill. Don't want to misrepresent that, but you've already heard comments about expansive. We need to go back to the extreme version. I can envision a mandatory reporter law at some point in the future. Schools are already mandatory reporters on abuse. The bill is introduced, opened that door, defined abusive behavior by specific words. This risks escalating personal or familial disagreements into formal legal conflicts, drawing the government into disputes that belong with families. The Commission's involvement could chill open communication between parents and children in the moment when it's most important that those communications be open, helpful, and now you got the government right in the middle of it. By classifying the failure to use a chosen name as a discriminatory act, 1312 redefines speech itself as a form of discrimination. Speech is now discrimination, granting the CCRD unprecedented authority to police language. This new reality threatens the First Amendment. The state could compel the use of chosen names while restricting the use of legal names, even in good faith contexts. For parents, this creates a chilling effect. Again, I'm deeply concerned about the wedge we're driving into that sacred relationship between parent and child. In schools, educators and students may self-censor to avoid complaints, stifling open discourse, essential to education. What's my time check? Oh, good. Then I'll just talk really fast. The CCRD's expanded role also risks inconsistent enforcement, as subjective complaints about name usage hinge on perceived harm rather than clear intent. You can never know what's going on in another person's mind. That's why we don't challenge or question motives here. You can't know. The motives may be pure. This could overwhelm the Commission, diverting resources from addressing tangible discrimination and setting a precedent for further speech regulation. So now you got me here defending the Commission, saying let's not throw one more thing on their plate that's going to get out of control. Such overreach undermines Colorado's tradition of valuing free expression and risks fracturing the parent-child relationship. The bill's emphasis on chosen names in public forums, this is again still in Section 8, and school policies, that's earlier in the bill in Section 6, creates a framework where the state prioritizes a child's preference over parental input. A chosen name must be used across public entities, if requested, potentially bypassing parental awareness. In schools, this could mean a child's chosen name is adopted in the records, classrooms, and communications without parental knowledge, further straining those family relationships. The intersection of these provisions with the Anti-Discrimination Act amplifies the risk of state overreach. Colleagues, parent-child relationship is the cornerstone of a free society. What we do is nibbling at the edges of things that are not fundamental until we bring a bill like this. And then we say, you know, that fundamental way that it has for millennia worked, we're going to upend that. Again, the AM/FM conversation. I'm not talking about adults. I'm talking about parents and children and what this act will do to the majority of the circumstances, the threat it creates in the majority of the circumstances. 1312, despite its protective intent, creates a system where schools and state agencies become the arbiters of deeply personal family decisions. By mandating inclusive name policies, enforcing gender-neutral dress codes, enlisting the CCRD to police speech, this bill risks transforming schools and courts into arenas where the state overrides parental authority. We must not allow government to intrude into and fracture the trust between parents and children. I urge you to vote no on 1312. Let's preserve the sanctity of the family unit and uphold the rights of Colorado parents to raise their children without fear of state interference. And at the same time, acknowledge that Kelly Loving was a hero who threw herself in between her friends and the threat that was coming at them. Thank you, colleagues. Thank you, Madam President.
You're welcome.
Mr. President.
You're welcome. Senator Kirkmeyer.
Thank you, Mr. President. The problem with the bill, quite frankly, is there's a few things, but it is the way that it started. It started on March 28th, about 5 o'clock in the afternoon, when it was introduced on a Friday, late Friday afternoon. Nobody's here on Saturday and Sunday. Nobody really knew about the bill. Certainly parents did not know about the bill. And then it was heard in committee on April 1st. The problem from the start were parents believed their fundamental right to guide their child's upbringing was under threat by the Colorado legislature. You know, last night as I was speaking, I received so many emails, no joke. Google disabled my account. Because I kept looking at emails thinking, why did they stop at 6 o'clock? Well, they did. And apparently my aide was responding and people just kept emailing. So they thought fraud was going on, so they stopped all my emails. So this morning I still received emails. I'm sure y'all did too. I'm going to read part of one that I received. It talks about strong opposition to House Bill 25-1312, legal protections for transgender individuals. This individual writes, I'm writing to express my unequivocal opposition to House Bill 25-1312. These are not my words, just want to remind everyone. This bill represents a deeply concerning overreach by the state and threatens to undermine parental rights, free speech, religious freedom, and biological reality under the guise of legal protections for transgender individuals. It says, there's some other language here, but then it says, House Bill 25-1312 would strip parents of their right to guide their children's upbringing and medical decisions, mandate ideological conformity in schools and workplaces by legally privileging gender identity over biological sex, threatens professionals, especially teachers, counselors, and doctors, with legal consequences for exercising sound judgment and personal conscience. It opens the door to irreversible medical interventions for minors without adequate oversight or parental consent. There's a few more paragraphs here, but the last line, I will be watching the vote closely and will hold lawmakers accountable for any support of this dangerous legislation. But I read to you what, and I got a few emails that are fairly similar to this. That's not what the bill does. Parents still think and are fearful they could lose custody or have their parenting time curtailed. They still feel threatened. They still think this bill does a lot of things that it doesn't do. That's the problem with the bill. It's the problem that it was introduced. All the work that the good senators from Broomfield and Centennial did, they don't really even know what happened. It's unfortunate. It's unfortunate how this bill got thrown out there in the first place. But what they do know is they felt threatened. And we got a lot of backlash. The parent backlash is what they see as inappropriate government interference. Parents have the legal right to review curriculum. They have the right to speak at school board meetings. They have the right to know school budgets, how they're being spent. They have the right to protect their child's privacy. And they have the right to know what measures schools are taking to keep their students safe. You've heard about parents' fundamental rights. But still in this bill, if you look at Section 6 and Section 7, they're not being consulted or informed about their child wanting to use a different name other than their legal name or how they dress. They still see these sections as a challenge. They still see these sections infringing upon their relationship with their child. So do I. These sections 6 and 7, when you relate those into, as already stated, conflicts with settled law that we already have. Section 6 does, Section 7 does. But when you add those in and you start looking at Section 9, which talks about the Colorado Anti-Discrimination Act, goes on to talk about how that the Colorado Anti-Discrimination Act prohibits discrimination based on protected classes and ensures that every Coloradoan is able to enjoy freedom from discrimination. So questions I'm getting now are, and it's not a lot, not yet. The questions I'm getting is, so if I tell my child, these aren't the state's children, this is my child. If I tell my child that no, you don't get to change your name, you don't get to have a chosen name, that we're still going to refer to you by your legal name, the one we gave to you at birth. Is that a cause for discrimination? Is that saying that parents are discriminating against their own child because they won't let them choose a different name? If I tell my child that, no, I'm not going to allow you to wear that to school, it's not appropriate, doesn't matter what the dress code says, I'm still your parents, I still get to decide. It's a clash with our values, I just don't like it. I've had to do that before. Is that they think of that as an intrusion in their parental-child relationship? But is that a form of discrimination? Because the law will go on to read that the General Assembly further finds and declares that Colorado has a long history of supporting freedom of choice for Coloradoans. I can already hear my 10-year-old grandson saying, he's a Coloradoan, he gets to choose. This includes the choice to make decisions related to safely seeking health care services, legally protected health care services, support mental, physical, and emotional well-being for Coloradoans, their children. But what about the kids? I mean, they apparently have the right to choose. So are parents going to end up in front of the Civil Rights Commission because they told their child what they could and couldn't wear to school, or because they keep calling their child by their legal name, not by some chosen name? That, to me, is the problem with the bill. I understand, I mean, if you go back to how this bill was introduced, and I do see now that in the unofficial pre-amended version, that Section 2 in the bill summary is deleted. But that's what parents thought. You know, we heard from the very beginning that people feel scared. Parents felt scared, but more they felt threatened. They know, I believe we all know, that parents are the first and basic educators of their children, and in particular with their moral upbringing and their beliefs. That's what parents do. Schools are supposed to add to the value of that education. They're not supposed to infringe upon it. they still look at sections 6 and 7, which to them are still sections, I think, 4 and 5. They're probably still looking at the introduced bill, given some of the emails I received this morning. And they just believe they've been threatened. They could end up in a custody case. They could have their parenting time reduced. It clearly, at this point, to them, doesn't matter about all the amendments, because they think the intent was that their parental rights were being infringed upon, that we were inserting ourselves between the relationship between them and their child.
Senator Crickmeyer, would you like to go into your next 10 minutes?
Yes, please. Thank you, Mr. President.
You got it.
I'm not going to be that much longer. I talked a lot last night. I appreciate what the senators did with their amendments. I appreciate that they were doing their best by listening and making those changes. I think that's good. That's what we're supposed to do down here. I appreciate that we all talked about emails and constituents and the number of emails we got. I mean, like I said, I got so many, they stopped my Google account for a while. We are state senators. Regardless if I get an email from Parker or Dove Creek or Sedgwick, those are still our constituents. Those are still my constituents. So I would ask for a no vote on this bill because there are still some things in it that interfere with the parent's relationship with their child. And I just don't think that's right. I don't think it's right to put educators and employees or an educator or a contractor in the middle of this. I don't think it's right that they should get to impose their values, possibly. I would just go back, we all have our quotes, and we heard from the good senator from Pueblo. I will just go back to a quote from the courts, who talked about family rights, who talked about parents' rights. And the court said, and this was in the Pierce decision related to education, the child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. I would say that we need to respect that parental-child relationship, and I would ask for a no vote on House Bill 1312.
Senator Carson.
Thank you, Mr. President. As legislators, it's tempting to legislate. I vote against a lot of legislation here because I think we legislate too much. And on this issue, we have people of many different views. We have people who feel strongly on one side. We have people who feel strongly on another side. And in the middle, we have a fundamental law in this state that says you shall not discriminate. You shall not discriminate on the issues that are covered by this bill, the Colorado Anti-Discrimination Act. And in my view, that's where we should leave it. We should leave it there. This is an issue to me that does not belong in the legislature. We live in a free country. People have their views. And I think this is an issue we should leave to families. We should leave to parents. We should leave to counselors. We should leave to medical professionals. And we should leave to individuals. And I will be voting no.
Senadora Gonzalez.
Thank you, Mr. President. Colleagues, I rise in support of House Bill 1312, the Kelly Loving Act. We often talk about those fundamental freedoms, those fundamental rights, inalienable rights. Life, liberty, and the pursuit of happiness. Life. Trans kids, trans adults, trans people report and has been documented have a 73% lower risk of suicidality after they receive access to care, after they're treated with the dignity and respect they deserve. Kelly Loving Act seeks to increase the amount of dignity and respect that we as a state offer to trans Coloradans. Liberty. We all deserve the freedom to make decisions about our bodies, our families, and our futures. Yes, I've heard a lot of emails. Yes, I've received text messages and phone calls, DMs on my social media. Hundreds of Coloradans showed up to testify both in support of and in opposition to the policy. What I didn't expect to happen was what I perceived to be the bad faith arguments from opponents to this policy related to aspects of the bill that were struck out. Continuing to foment fear is the opposite of seeking to further meaningful policy. Y'all, this is what we are sent here to do. I joke a lot of times. I got 0 wolves in my district. But I'm expected to understand and respond to and create space for individuals who are and communities who are directly impacted by wolves. Cool. To the legislators, my colleagues, to those of y'all who said, well, I didn't hear nothing from nobody from my district who was supportive of this bill. There were comments made yesterday about, oh, well, the only people who support this bill, we went through and with stunning precision and detail outlined the fact that, well, a lot of the co-sponsors of this bill tend to be from Metro Denver, from the Front Range. Heck yeah. Because what I've heard in my conversations with the folks who came to testify and advocate in support of this policy is that that sometimes rural Colorado ain't a safe place. to be trans. So, yeah, that tracks. It also makes me wonder, in the midst of great shift in our society, why this bill is such a lightning rod and a touchstone for such grand opposition. About language that was either never in the bill or that was struck out from it. Makes me wonder how we would have, had we been this body, this cast of 35, how we might have grappled with other issues, grand societal changes. Makes me wonder, as a Chicana, how we would have debated parents' rights when it comes to suffrage, parents' rights when it comes to desegregation, liberty. I've heard a lot of I've heard a lot of remarks about the testimony that we heard in the Senate Judiciary Committee. What I think opponents to this bill fail to acknowledge and reference in their summarization of the hours and hours, 8 hours of testimony that we heard related to the policy were from parents saying, I have done everything that I can in order to keep my kid safe, in order to keep my kid alive, and that's why I'm advocating for this bill. Because what happens when you have done everything in your power as a parent? It ain't enough. That's why this bill matters. We heard testimony from parents, testimony from trans adults who held space for the parents who in some cases had abandoned them. That's why this bill matters. I heard testimony from a trans adult who came to Colorado. She came to Colorado from Kansas. And I said, first things first, major upgrade.
Senator,
Colorado.
would you like to go into your next 10 minutes?
Yes, Mr. President, I would.
Very good. Major upgrade.
Major upgrade, moving from Kansas to Colorado. When you are, and I asked a question of her, when you are intentionally dead named, misgendered, what impact does that have on you as a person? And I have to say, the level of grace that she carried to be able to say, I've done the things, I've had the conversations with HR, nothing happens, but also I try to have grace and empathy. I don't know that I would be as forgiving. To say, I know that it's hard, I know that things are challenging, but in the midst of so much societal animosity and angst, to be willing to, in the midst of everything else, on that level, to still find empathy for the person who's intentionally misgendering, misnaming, dead-naming her. That is a level of empathy that I one day aspire to achieve. This bill is a step forward. There is so much more work to do. But it is a step forward. In the midst of a time when Coloradans who have served our country are being targeted and kicked out of the armed forces for living their lives as who they are, and everyone on else and down and in between. This bill is a step. To the Coloradans who opposed, past tense or present tense, this policy, I hope this bill gets signed into law so that you can see that the world ain't gonna fall apart, that the sun will rise again in the morning, that maybe, if it's not your kiddo, maybe it's your kiddo's friend who receives the support and care and affirmation that they need in order to live. In their pursuit of happiness, in their pursuit of liberty. One of the most powerful voices, I wrote it down because I was just stunned by the precocious words from this kiddo who ended their testimony saying, look, just because I don't fit into your box doesn't mean I don't fit into your community. Ollie, thank you. At a time when maybe not everybody understands the experiences of the 500 trans Coloradans who built the survey that led to the introduced version of 1312, who worked diligently, tirelessly, at times with opposition, at times with critical friends and allies, to achieve the revised bill that we now debate here before us. I say thank y'all, because work that is worthwhile is never easy. And may that be an indication of just how much it matters. Thank you all for the work that you have done and will continue to do until every Coloradan is able to live with freedom, justice, and dignity. I ask for an aye vote on House Bill 1312, the Kelly Loving Act.
Further discussion? Senator Colker.
Thank you, Mr. President and colleagues that have spoken already. Appreciate all the time and thought that's gone into the speeches and the conversation that we've had over the last 24 hours especially. I think it's time to do a level set. I think it's time to make sure that we discuss 1312 and what's actually in the bill and not what is assumed to be in between the lines of the bill. I heard, and I'm going to start with a statement that was stated before, that you can support transgender people without trampling on other people's rights. First of all, that phrase is used to suggest a zero-sum view of civil rights, that protecting transgender Coloradans must somehow shrink someone else's freedoms. 1312 rejects that premise. It reinforces an existing civil rights framework in the Colorado Anti-Discrimination Act. By adding clarity and enforcement precision, it does not create new superior rights for transgender people, nor does it strip rights from anyone else. In the practical terms, it says you may not deny someone housing, employment, or public services because they are transgender. That public forums must respect a person's chosen name and gender marker when they have been legally recorded. And the talk about what this says about schools and what schools do and how parents' rights are infringed. It just redefines a local education provider. And then it says, if that local education provider is going to have a policy, if it chooses to enact or enforce, that's local control, chooses to enact or enforce related to names, that policy must be inclusive of all reasons that a student might adopt a name. And what really that means, if we're going to talk about in between the lines, that if they're going to call and set up a policy where they inform parents of a transgender student wanting to change their name, they must inform parents of another student who's using another name from the name that they were given in school and wants to be called. The only other part about this is the Board of Education Safe School Plan, and this was just rewritten as it is in statute under Section 7, so that it makes it easier to understand what they're stating under Conduct and Discipline Code. The only change there in that first paragraph is copies of the code from shall, crossed out, to must be provided to each student. That's it. And then at the very end, talks about dress code, which my daughter is very well aware of in her school, because she feels it's inequitably and there's an unequal enforcement in the dress code between students. And that dress code must allow each student to choose from any of the options provided in the dress policy. That's it. That's it. That's what we're talking about here in schools. We're not talking about taking parents' rights away. I know students go to school dressed a certain way when they leave the house, but when they get to school, they're dressed a different way because their parents don't know. All right? And it has nothing, it's just what that child wants to wear. Okay? And they come back and they change before they get back home. And that's not about transgender policy. That's about what that kid's choice is, right? So we're just leaving it up to the schools to enforce policy, to establish a policy and enforce it and make sure that that's equal amongst all kids. We talked about government forms, changes to government forms. And I have an email that I received from a constituent that I want to read parts of on why this is important. I live in your district. I'm asking you to support 1312 because transgender Coloradans deserve the freedom to live with safety, dignity, and access to the care and recognition they need to thrive. 1312 is critical in removing barriers to changing documentation that my wife and I were forced to hurdle over ourselves. Having been married prior to my transition and without this bill in place several years ago, my wife and I were forced to legally get divorced and then remarried to change both my name and my gender from bride to groom on our marriage certificate. Because we have children, we are required to attend parenting classes as part of our divorce, develop a parenting plan, disclose and divide all of our assets, and attend several hearings and conferences, only to get remarried 6 months later. Both processes that wasted time for us and the court and cost us hundreds of dollars, all to change a name, a gender marker. This bill sends a clear message. Colorado is a place where trans people are protected, respected, and valued. At a time when anti-trans legislation is sweeping the country, our state has the opportunity to be a beacon of hope and a model of what's possible when we act with courage and care. From Sean in Centennial. This bill's needed because if transgender residents were never harassed, denied services, or mocked in official settings, additional clarification would be unnecessary. The lived evidence shows that gaps persist. And the emails show that gaps persist that we received. I received one such, and it talks about differences in ideology. It actually says, that this bill undermines people and is evidence of an evil ideology from the pits of hell. It's an email I received this morning. I just thought being gay was being gay, being transgender was being transgender. You see, when I first met my colleague here 8 years ago, down in North Carolina at a conference over a weekend, I was asked to sign in and give my pronouns. I'd never been asked that before. That was all new to me. I was a little confused because I'm me. I'm a little confused sometimes, right? And I didn't understand. But then with talking to other people that were at the conference and then living life's experiences over the last 8 years, I got it. I understood. People have pronouns. People are different. But that doesn't impact me. Only if I'm purposefully, angrily harming someone, right? Only if I'm discriminating against that person. Doesn't matter. I mean, we've got lots of other names that we call people we don't say, right? That we don't want to use for discrimination. But I've grown to understand where this need is, where these people, where all people are, and where we need to meet people. This email, I'm going to end it here, says, basically, I'm accountable to Almighty God because I'm standing up for equality. That my decisions one day, I will stand before Him and be accountable. Well, this is what I believe. You ever seen that movie, Talladega Nights? And you see that section where they're talking around the dinner table and they're talking about what their favorite version of Jesus is. All right, baby Jesus. I love baby Jesus. And the guy goes, well, I love Leonard Skinner Jesus when angels are behind him and the choir is singing and he's playing Freebird. Well, on my day of judgment, I might be standing in front of trans Jesus. I don't know. I don't know. It's what I believe. And I believe that Jesus, God, will look at me and say, you stood up for people. You stood up for those who were less fortunate, who struggled. You may pass. You may enter. I encourage an aye vote.
Further discussion? Senator Winter.
Thank you, Mr. President, and thank you to the conversation on this incredibly important piece of legislation. First, I want to talk about families. Families are incredibly important. This isn't about destroying families. I think this is about strengthening families. I want to share some of the texts that I've actually just gotten while sitting here from moms. This is one mom. As a mom, what I want more than anything is for my children's doctors, teachers, providers to see my children as whole people. As children grow up, they also grow in their understanding of themselves, including their gender expression. Treating our children with dignity, trusting our children to know themselves is our best way to save their lives. And I support them to grow up to be safe and healthy adults. That's a mom of a transgender teen. Another mom texted me and said, thank you so much for running this bill. Our kids' communities are really scared right now. And although my children, both queer kids, are no longer minors, it's still reassuring message that the legislature is creating a safe environment. Another mom said, as parents, we are proud to see Colorado reaffirm their commitment as a trans-friendly state in removing unnecessarily and frankly mean-spirited targets on some of our most vulnerable. Thank you for ensuring access to care and overall well-being for our transgender community. We also heard from teachers in committee that said, I don't want to out a child. I want to educate a child. I want a child to be successful in school. I want them to have good mental health. And that teacher said, take a vote of care and vote for this bill. And that brings me to one of those children that we are working to protect. And this is a letter that they wrote and said, I feel it's incredibly important to share my perspective with you on 1312, otherwise known as the legal protection for transgender individuals. And this is a child that goes to Legacy High School in my district. And according to the study posted by NIH, titled Suicidality Among Transgender Youth, Educating the Rule of Interpersonal Risk and Factions. Among the population of transgender individuals, 82% have considered suicide, and 40% have actually attempted ending their own lives. Those statistics are not acceptable. Not only that, but I have personally witnessed what my transgender peers struggle with in discrimination they face in public and the lack of support they have at home. The rejection transgender youth have faced could severely and irreparably traumatize a growing child, whether they identify as transgender or not. Another study published said perspectives of transgender youth or parental support, qualitative findings from the Resilience of Transgender Youth study states that parental support is crucial to the vitality of transgender children's mental health. We talked a lot about families, not getting in the way of families. These are transgender families that are saying their education systems, their public accommodations, their walk in the world is getting in the way of them affirming their children. And unfortunately, children don't always get affirmed. We know that transgender youth are more likely to experience homelessness, suicidality, mental health. It's harder to get a job. This bill doesn't say you can't talk to your child. This bill doesn't say you can't bond with your child. And so this is a bill to strengthen families. This is also a bill that I carry with me spiritually. Truly, I tell you, whatever you did for one of the least of us, these brothers and sisters of mine, you did for me. I come to this building every single day trying to do what is best for the least of us. And when we have executive orders coming down that are kicking out veterans that have been serving for 12 years in the military and risking their life, and they are told overnight that they can no longer serve in the military. When there are shootings, when there is discrimination, we know that transgender folks are living in fear every single day. So what are we going to do today for the least among us? What are we going to do today? I hope that we vote yes on this bill. And I want to share a text I got from one of these individuals that we're working to protect. I had never visited the state capitol in Colorado before. I don't know what happened in this building. I did not meet a senator. I didn't even really know that these things happened. That changed all with 1312. I'm a transgender woman. When I saw the bill, I knew I had to get involved. I have been unsafe most of my life. That changed from fear to despair in January, when executive orders came on criminalizing me and making me a second-class citizen. 1312 gave me hope for the first time in many months, honestly, in years. I will be able to work safely. I will be able to be in public with less fear. These are really simple things, but it's something I haven't had since I came out 4 years ago. And I just want to end by reminding you that this is the Kelly Lovings Act. And Kelly Lovings unfortunately died in the Club Q shooting. That shooting happened because people are scared and they don't like and they fear and they hate transgender folks and LGBTQ folks. They were put at risk because of where they were in community. And just to clarify, Kelly Lovings was celebrating her 40th birthday, but she was from out of state. When she put herself between bullets and others, she didn't know who they were. And if she had that amount of love to protect her community, I ask you to find enough love to protect those that are least among us, who are amazing, and vote yes. Kelly Loving was known as a butterfly because of her protection, her support, her empowerment, her belief in this community. And this is the most empowering thing we could do today. Please vote yes.
Further discussion? Seeing no further discussion, the motion is the passage of House Bill 1312. Are there any no votes? Senators, Mr. Minority Leader. Kirkmeyer, Frizzell, Rich, Pelton R., Catlin, Baisley, Liston, Carson, Simpson, Pelton B., Bright, Mullica, Snyder, with a vote of 20 ayes, 14 noes, 0 absent, 1 excused, House Bill 1312 is passed. Co-sponsors, Senators Michelson Janae, Kipp, Gonzalez, Wallace, Danielson, Cutter, Amabile, Weissman, Marchman, Henriksen, Ball, Bridges. Please add the president. Majority Rodriguez.
Thank you, Mr. President. I move to lay over the remainder of the third reading calendars till later in the day.
The motion is lay over the remainder of third reading of the bill's calendar later today. All those in favor say aye. Opposed, no. The ayes have it. And that motion is adopted. Mr. Schaffler, please add Senator Exum to the roll. Oh, he has to come back in here. Senatorial 5. Mr. Schaffler, please add Senator Exum to the roll.
I think I'm ready. We're going to go to approps.
Majority Rodriguez. Proceed out of order for announcements. Announcements, Senator Amabile.
Okay, thank you, Mr. President. We are going to be having one last appropriations meeting.
Yay!
Yay! In 10 minutes. In 15 minutes.
Right here in the well.
No, we're going to go up to room 357, and we're going to hear House Bill 1078. See you up there.
Very good. Further announcements. Seeing no further announcements, Majority Leader Rodriguez.
Thank you, Mr. President. Colleagues, we'll be breaking for appropriations, and then we'll do a call of the Senate to come back. Take a little time. take some time to relax, enjoy. I'll decide when we call back the Senate. Take a little break, and we'll come back and get back to work. On that, Mr. President, I move the Senate recess until 2:15 p.m.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. Senate will recess until 2:15 p.m. in the Majority Leader's office where there are snacks.